till the time Shikha is joining, I'll start the session now, sir. So, first of all, I'd like to thank the ICSI chapter for giving us this opportunity to address on this topic. It's a very interesting topic. So before starting, I'll just share my slide once. I hope the screen is visible to all.
Yes, ma'am, it is visible.
Right. So the topic today is about analyzing current issues in liquidation under Insolvency and Bankruptcy Code and the future reforms. When it comes to analyzing the current issues in liquidation, I believe that before getting into the issues, it is better to understand or have a quick recap of the liquidation process first as to what liquidation process is all about. So today we are going to discuss regarding the liquidation process. We'll give a quick overview of the liquidation process. We'll discuss about the important aspects of the liquidation process. And then we will deal about the potential areas of discussion, which includes the collation and verification of claim, secured creditors, role of and constitution of stakeholder consultation committee, inter se priority between the creditors, then treatment of workmen or employees dues, which includes the dues relating to their funds which are created pursuant to a statute. And then treatment of avoidance transaction proceedings, liquidation cost, what includes within the ambit of liquidation cost and what does not include. And then concerns with respect to voluntary liquidation matter, going concern sale matter, scheme of arrangement, and the other aspects. So let us quickly start with the overview of the liquidation process. When we say liquidation process, it is about liquidating a company which is insolvent. We all know that Insolvency and Bankruptcy Code has started from 2016 and it continues till now. Several amendments has been introduced in this sector as well. So these code, the Insolvency and Bankruptcy. Insolvency is about resolving the company, giving a chance to the company to revive. And when it comes to bankruptcy, it is about killing the company when there is no chance of revival of a company. So the CIRP process, which we generally call corporate insolvency resolution process, we are giving a chance to the company to resolve once again or to get into the track back again. However, if there are circumstances pursuant to which the resolving the company is not possible, in that case, the company goes into liquidation process. So what are the circumstances under which the company goes into liquidation? There can be a decision of committee of creditors to move the company into liquidation prior to expiry the CIRP period. When they see that there is no way of getting a resolution plan in a particular corporate debtor, then COC may decide to go to the liquidation process. When there is no resolution plan received, then COC may decide to bring the company into liquidation. When a plan is received but not approved by the COC, then also the corporate debtor goes into liquidation process. When a resolution plan is approved by the COC, however, not approved by the adjudicating authority, in that case as well, the company goes into the liquidation process. And last but not the least, when resolution plan is approved by AA as well, adjudicating authority as well, however, is contravened, in that situation as well, the company goes into the liquidation process. So this liquidation process has to undergo with the CIRP process. That is to say, one chance is to be given to the corporate debtor to revival first. And if the revival of the corporate debtor is not possible, in that case, the company goes into the liquidation process. That is, the process of killing the company begins. Now, let us quickly see as to what this liquidation process is all about, the steps which are involved in the liquidation process. As I said, that the process starts when the plan is either not approved, or if approved is not implemented properly, or either not approved by COC, either not approved by adjudicating authority. In either of those circumstances, the company goes into the liquidation process. The day on which the order is passed by the adjudicating authority is generally termed as a commencement of liquidation commencement date. And the timelines has been provided mostly connection with this liquidation commencement date only. So the process starts with order of NCLT. After getting the order of NCLT, a liquidator is appointed. Liquidator can be the same person, the one who was carrying on the CIRP process, or can be a new person as they be decided by the adjudicating authority. Once the liquidator is appointed, There is no role. The board of directors seizes their power. The employees and workmen also released from their duties, and then the liquidator takes the possession. After taking the possession, the liquidator is required to invite the claim by making the public announcement in the widely circulated newspapers. The purpose of this public announcement is to invite the claim from most of the creditors of the company, most of the stakeholders of the company, and there's a timeline given within, and forms are provided within which the creditors are required to submit their claims. The format of submission of claim is also provided within with the by which the respective creditors are required to submit their claims to the liquidator. After receiving the claim, the liquidator is required to collate the claim and prepare a list of stakeholders. After preparing that list of stakeholders, the liquidator is required to constitute a committee, stakeholder consultation committee. That stakeholder consultation committee is for the advisory role and is not like the committee of creditors that we have seen during the CIRP process. As in the CIRP process, the role of committee of creditors is of decision making. However, when it comes to the stakeholder consultation committee, the formation of stakeholder consultation committee is different. As in COC, the stakeholder, only the financial creditors are involved. When it comes to SCC, stakeholder consultation committee, all the stakeholders are involved. The process is provided under regulation 31A as to who will form part of this SCC. After formation of SCC, the liquidator is required to determine the liquidation state as to what is to liquidate. So that state has to be created, that these are my state and I am required to liquidate these assets only. Something which is not included in the liquidation state is also provided as to what will not form part of the liquidation state, that is provided under section 36 subsection 4. So I am required to liquidate this liquidation state which has been formed. Then I'm required to submit a prelim report along with asset memorandum. I'm required to appoint the valuers for conducting the evaluation of the assets, and then to realize the assets, sell the assets. There are modes prescribed pursuant to which I can sell the assets. Modes are going concern sale, slump sale, piecemeal basis, and others. So I am required to realize the assets. There can be a situation that a corporate debtor may have different kinds of undertaking. So liquidator is required to analyze as to what which kind of assets has to be sold in what manner. So in using a particular manner which can maximize the value, the liquidator is required to realize the assets. After realizing the assets, the main part comes, which is about distribution of the realized proceeds. Section 53 of the code provides as to in what manner, in what hierarchy the realized proceeds has to be distributed among the stakeholders. So the realized proceeds is to be distributed among the stakeholders in terms of the provision of section 53. And after distributing the realized proceeds, the liquidator is required to file the respective application with the adjudicating authority. This application can be of dissolution application in case the slump sale has happened in the company. However, in case when the concern has been sold by way of a going concern basis, in that case, there will be no question of filing a dissolution application. There will be a completion application to be filed with the adjudicating authority. And adjudicating authority, after taking note of the process followed by the liquidator, the manner in which assets has been realized, the manner in which the distribution has been made, the adjudicating authority will pass the order for the dissolution or will take note of the completion of the process. The order has to be then filed with the registrar of companies. So this is about the steps which are included in the liquidation process, a broad summary of the process when it comes to liquidation of a corporate debtor.
Can you, can I just take a second? Can you divulge more upon the completion application, liquidation completion application, and the other one that you spoke about?
So I'll discuss about all these things
sure.
during my session, during the representation of the remaining topics. I'll cover those parts as well. Now coming to the important aspects of liquidation process. What are the important aspects? The important aspects of liquidation process are, of course, creditors for whom we are doing all these processes, for whom we are realizing the assets, we are making the, we are analyzing the best mode to realize the maximum possible value of the assets of the corporate debtor. So creditors. The creditors' role is different when it comes to CIRP process. Role is again different when it comes to liquidation process. However, the entire process is for the benefit of the creditors. Second is about liquidation state. What will form part of the liquidation state, what will not form part of the liquidation state, what is not within the jurisdiction of the liquidator to realize, because liquidators, of course, is playing a role of a fiduciary. It is very important to understand that something which is not included or on which a liquidator does not have a hold on, liquidator cannot touch that part. Liquidator cannot exercise jurisdiction upon those assets. Hence, exclusion has been given to those assets which cannot form part of the liquidation estate. Then realization and distribution, which is all about the IBC process to realize the assets and to make distribution. Realize based upon the options which are given in the insolvency and bankruptcy code, read with the respective regulations, be it CIRP regulation or liquidation regulation, so or voluntary liquidation regulations as the case may be. And then after realizing the assets, then to make the distribution in terms of the priority or the hierarchy which is provided in section 53 of the code. Coming to the reasons of liquidation. So there is the statistic data latest that we could have achieved, or we could have find is based on the data as on 30th of September 2022 that shows that COC has decided to liquidate the corporate debtor during CIRP process in most of the cases. Some 11,052 cases were there. Then in some cases, adjudicating authority did not receive any resolution plan. In some cases, it has been seen that adjudicating authority has rejected the resolution plan. Or in some cases, it has been seen that corporate debt has contravened the provision of resolution plan. So there can be several, as I said, that there can be several reasons for putting a company into liquidation. So of course, for once the liquidation process starts, doesn't matter as to why at all the company goes into the liquidation, because it's all again a new process that commences with the start of this liquidation process. However, this is the statistical data that shows that on what basis or what are the major reasons based on which the liquidation process of the corporate debtor has started. Again, there's a data that shows the long drawn liquidation and depletion in realization. This entire statistic that shows as to in what manner, in how under the liquidation process, how much claim has been realized, how much distribution could have been made. And
Barsha, here I would like.
Yes.
And we are discussing today, today's topic is current issues in liquidation and the future reforms which we would possibly want to have in the process. So when we talk about issues, we are actually questioning the present efficiency of the process. As in, when we talk about liquidation process, we are talking about efficiency of the liquidation process. And when we talk about efficiency of the liquidation process, basically there are two aspects. Two factors I can say. Number one, the timelines. Number two, the value realization. So if these two are in sync and if these two aspects are efficient, the process itself would become efficient. Or rather, we can say an efficient liquidation process should yield to results like strict timelines, like achieving the result in quick timelines and higher value realization. However, when we see the data, this efficiency comes in question mark. So when we look at data, we would see that, more than 50%, approximately 50% of the cases are anyway gone beyond 2 years, right? And when we talk about this realization data, we see that when we look at 53(1)(b), which is the after the cost, which is the highest value, highest priority creditor, claims are 6,993, approximately 70,000 crores, while the distribution is actually 2630.86. I think that roughly comes out to in below 0.05%. So what we are meaning to say is that even in terms of timelines and in terms of value also, the liquidation process is not yielding the results as is expected. So definitely there are some gaps in the process. Yes, of course, the IBC in itself is a major revolution in terms of default culture and in terms of, say, realization resolution of the entities. However, there might be some gap. So Barsha, I hope you have discussed about the discussion paper which just came yesterday.
No, I've just given the prelim idea about the liquidation process. Shikha, you may continue further now.
Okay, sure. So it would be relevant to note here that while we are discussing the issues in liquidation and reforms here, yesterday only IBBI came up with a discussion paper where not only liquidation, the committee has actually talked about, MCA has actually talked about a wide range of reforms across the entire IBC, including CIRP, including pre-pack, including going concern sales, everything. So we will try to cover all those aspects, basically relevant aspects in the course of our discussion. If we recall, if you feel that the same is relevant here, although those aspects could not be covered in the presentation itself, but to the extent we recall, we'll try to cover those aspects as well. Barsha, I am sharing the screen. Will you allow me to?
Right.
Yeah. Yeah, I hope that is visible.
Yes, it is.
Yes, Shikha,
Yes.
it's visible.
Yes. So here we have kind of collated, just a minute. Here we have kind of listed out some 10-12 areas of discussion which we felt are of more important relevance. At the end of the session, we'll of course pause in between to have your views and questions as well. But at the end of session, we would want to have a freewheeling discussion. We would want to have your experiences and take your inputs as well, because you are also in the practicing field. So you will also you can also share your personal experiences with us in the entire process and give us inputs. And this is a good opportunity, as in, since the discussion paper is already out and the government has anyway sought comments, then we can anyway give other comments as well. So the potential areas of discussion which I and Barsha would be discussing today relate to various aspects. For example, in the entire claim collation and verification process, rights of secured creditors in the liquidation process, including their inter se rights and priorities in between, treatment of employee benefit funds, what is the position of tax dues. In the last few sessions, as I understand, you would have discussed some landmark decisions of Supreme Court. So two of those important landmark decisions would be, one is Vidarbha Industries, second is Rainbow Papers. So while the Vidarbha Industries have talked about the discretion of NCLT on deciding whether default has actually occurred, whether that makes sense to drop the CD into IBC process and all. So that was one important SC ruling, which was different from the common understanding. Plus there was a ruling on Rainbow Papers, where tax authorities, due to statutory charge created under tax provisions, were treated at par with secured creditors. So again, that necessitates some sort of clarification, and this IBBI discussion paper also talks about it. We'll discuss that in detail. Now, role of SCC, this is a contentious issue, I would rather say. Various aspects relating to avoidance proceedings might also necessitate some sort of reforms, or maybe plugging holes here and there. Consolidation, moratorium aspects during liquidation. One of the most important aspects is declogging of NCLTs, and we'll discuss how there are various ways in which we can actually lower the burden on our NCLTs. There are other aspects relating to liquidation process as well, going concern sales and schemes of arrangement. Plus, as we saw earlier, in the earlier slides, Barsha showed certain figures. As in case of general liquidation, as in compulsory liquidation, the timelines are startling, as in 715 days for the final report submission, 906 days for dissolution, which means that approximately on an average between filing of final report and dissolution, a time period of say 200 days on an average is being taken. So in this case, it is still understandable that given the compulsory liquidation, we are going against the promoters, there can be complexities, litigation here and there. That's why these timelines. But in case of voluntary liquidation also, where there can be simply plain vanilla scenarios, shareholders, promoters are all aligned, creditors are aligned, there shouldn't be any such concern, right? So in that case also, average time taken is approximately 1 year, and dissolution in fact takes 745 days. So final report and dissolution itself, the time lag is approximately 1 year. So of course, we might need certain reforms in the area of voluntary liquidation also. And then there would be other aspects which we would discuss, and we will also invite your suggestions as well. Now, to start with claim collection and verification process. Right. So as of now, the process for collection of claims by the liquidator and verification is contained in sections 38 to 42 of the IBC, read with regulations. Now, so what is the existing process? The liquidator collects, basically the creditors file the claims, liquidator collects the claim in case, whatever the decision of liquidator is, he communicates that decision to the creditors, right? And now there is a provision under section 42 which says that if the creditor is not happy with the decision of the liquidator, he can directly appeal to NCLT. Now, a common problem is delay in submission of claims or either non-receipt of claims. So what happens is sometimes we have even encountered cases where the claims were received after dissolution of the entity. Might sound funny, but this has actually happened. So, and not only once, but multiple times. So what happens is claims are either delayed, and we also see that in most of the cases involving income tax authorities or say government authorities, claims are not even received. So what to do in all such cases? Say in case of a delayed claim, the creditor comes up to me, I am the liquidator, I have to tell, I have only 30 days to collect the claims. So I have no authority to collect the claims any further. What I have to do is to reject the claim and say that your claim is denied, your claim is delayed. I am not empowered to accept the claim, and therefore you need to go to approach, you need to approach the NCLT for getting a condonation of delay. Now this is a burden on NCLT, plus this is a time consuming process for the creditor as well as the liquidator. So ideally there is a possibility of giving the powers to liquidator so that he can, within some grace period, say, can itself condone the delay by the creditor. Plus there can be a deadline for acceptance of claims beyond which no claims could be accepted. However, if we talk about the recent IBBI discussion paper, what it says is to completely do away with section 38 to 42. It says that there should be no need of section 38 to 42. What should be the ideal scenario is the liquidator should directly rely on the claims received during CIRP and accept that as well, so that there is no duplication. Now, that particular approach might have certain disadvantages because the claims as on CIRP commencement date and the claims as on liquidation commencement date might differ in value. Might, and in fact, in most of the cases would differ in value because of accrual of further liabilities. So that is one point which we need to kind of see how to go about it. And we'll also want to respond on those lines to the IBBI discussion paper. Now coming to verification of claim of secured creditors. Again, when we see the regulations, liquidation regulations, it provides me three options. Number one, my security interest is registered with SASAI. Number two, my security interest, I've kind of registered those details with the information utility. And number three, my details are registered with the ROC. But when we see section 77 of the Companies Act, it says that in case the charge is not registered with ROC, the charge becomes invalid. So what is the proper stand to be taken? Should I only accept the claim of the secured creditors in case there is ROC registration and deny all the cases? Interestingly, in this IBBI discussion paper, this particular MCA discussion paper, the proposal is that ideally, while accepting the application, they are talking about not the claims but the application. While talking about the application, only the information filed with information utility should be seen and not any other evidence. So that creates some kind of a multiplicity, that creates some kind of a confusion, and also some sort of inflexibility for the creditors. So that also needs to be explained as well. So that is one part relating to collation of claims and verification of claims. Barsha, in case you have anything to add, or else should we invite questions, if any?
I think we can invite questions now.
Yes. So in case we have any questions till date, because we'll be further discussing about secured creditors, etc. In case we have any questions, we can take that up, or else we'll move forward.
Participants, your opportunity.
Yeah, just suggest one thing. When
Sure.
many of us are finding that the books, the CD doesn't, they do not give the books, proper books and all. In such circumstances, how you're going to verify the claims? We have to depend only on the documents that is being provided by the claimant.
So, sir, you are talking about inavailability of the books and records of the.
Yes, in most of the cases, I'm seeing so many cases where they are not cooperating at all.
So,
Under
sir,
such
that
circumstances,
non-cooperation is again a very commonly found issue.
but
And that
no solution. Even the board, even the NCLT, they could
Correct.
not give any stringent direction where this could be complied with.
No, sir, I would not say that. We even we as liquidators also experience the same, and we also filed for application where we kind of vehemently sought for relief in that case, where it was a clear case of non-cooperation and directions were given. Although of course it took time, but directions were given, and the promoters were bound to cooperate in those matters. That was not particularly relating to books and records, but yes, there were certain things for which we got the orders. And in this case also, ideally, while you have two options. If it is possible to verify the claims basis, whatever the records filed with, for example, say you want to verify a claim with the secured claim of the secured creditor. Now, as per the Bankers Evidence Act, we have those certified copies of all the statements. Charges you can find from the index of charges and other documents which are given, say the agreements, even the creditors would annex the agreements. Like you can see the agreements, you can rely on those agreements, and we may not go back to the books and records of the CD. To the extent it is doable, we can do that. To the extent we genuinely need the records, books and records of the CD, we can seek the help of NCLT. But in any case, if there is non-cooperation, ideally the right way to approach is to go to NCLT. Barsha, if you have any
Shikha, I'll just like to add.
My name is
here
Brijendra
that
Kumar Mishra. I think my friend is talking about.
Yes, sir. Yes, sir.
My friend is talking about the secure financial creditors other than bank. Okay, so in that case, though we are given the books of accounts, but books of accounts are unable to show anything. They are having only opening entry for last 2 years, 3 years. So we are anyway unable to verify the amount of claim, whether it is belonging to one creditor or other. So that is the problem. Books of account they used to give in a teleform, but those books of accounts doesn't have even a single line other than the opening balance, and opening balance is coming from last 3 years, 4 years. In that situation, we are unable to verify those claims, particularly from the books and accounts. And the case under section 19 do for non-cooperation also does not fall under. So under these situations, what should we do?
Even in those cases, sir, even the company is not making any reconciliation of the balances with the banks. For years,
sir, that is another thing.
Same balance.
I have came across a case where in last 4 years, only one opening balance in the period accounts of the creditors, and they are not given any single voucher, nothing. And in that case, and they may say that, okay, last 3 years back in period books of accounts they have given. So under that situation, we have no option but to whatever they have filled up the claim, we have to accept it, because books of account doesn't speak anything. That is the problem.
No, sir. If there is an opening balance, there have to be certain transactions, due to which this opening balance or closing balance is coming. So ideally, the promoters, the erstwhile directors of the CD should be providing you with those details, as in where is this opening balance is coming from.
No,
I think that they are talking about the situation when they are not getting any kind of cooperation from
we
the
have filed
promoters.
I tell you, we have filed this application under 19.2 also, and then the NCLT member ordered that, okay, you provide details, but rest during this period, the 6 months, 8 months, 9 months passes, and we are clueless in that case. So that is the particular problem, because opening
court. No,
when NCLT passed an order, what we can do?
Sir, I understood your concerns. I'll just like to mention here, I'll just try to add upon what Shikha has said. that when it comes to verification of claim of a creditor, you have two options. First, either to rely on what the creditor has submitted and verify that. And if you want to also verify that the same with the books of the company, then rely upon the books of the company as well. Now, say suppose there's a situation when nothing is there in the books of the company, or you're not getting any data, particularly from the books of the company, or not getting any cooperation from the promoters or directors of the company while adjudicating the claim. In that case, of course, you are left with no other option than relying upon the documents that the respective creditor has submitted to you with respect
Exactly
to
my point.
substantiating
Exactly my
their
point.
claim.
That is there. That we are means that in that case, verification, we can't say that we have verified the claim. Whatever they have given, we have accepted it. That is the only thing.
Exactly. That is just collating that is just collating the
Collating,
claim.
just collation of the claim.
So because if again, you can see that if at all there was any agreement, whether at all there is a signature of the ex-director of the company in the particular agreement that they have entered into. In
Yes,
case
that
of
has to be
operational creditor where
Naturally,
there is a
naturally,
particular
that will
voucher,
be
etc.
that will be
I
provided.
tell you, those
We can
everything will
counter
be
it. That is the
provided.
thing.
Though, because it is the informally I can say that there is no other proof. It is all created by the promoters and there, and that can be done. All agreement there, whatever document you ask from the claimant, they will give. But your books of accounts of the corporate debtor doesn't speak even a single sentence whether this claim is stands or not. That is the issue. Even
Well,
then,
sir,
books of accounts are given.
I believe that these issues every insolvency professional these days are facing, of course.
No,
There are
not all,
several
not all. In
aspects.
few cases, it is there. Not in all cases.
At least
But
there would be
in few.
something
Most
in
of the
the there would be
cases, yes.
something in the books, Barsha. There would be something in the books, at least some sort
Only
of
opening
balances.
balances. Only opening balances for last 3 years, 4 years.
And there would be balance, there would be amount mismatch also.
Four,
There would be amount mismatch also, for sure.
Yes, 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 yes.
So, Barsha, we will need in those cases now, we need to have some tangible proof. Matlab, merely
Absolutely,
relying
yes.
on what the creditors is giving might be actually dangerous. That's what
Like,
I feel.
again, this we can also say that this is also an area that requires clarity as to what will be the position and how the liquidators should adjudicate the claim when there is nothing in the books of the creditor. So how to adjudicate that whether the creditor, what is the submission of the creditor is correct or not, or how to verify this the same, because the role of the creditor is about verification and it's not just limited to collation of the claim, right?
So here the word verification is not being complied with. That is what I am saying. It is just a
Yes.
collation because you don't have anything to verify from.
Yes, sir.
Okay. Coming to any other questions, or should I move ahead?
Yeah,
So I'm
continue. Please
Yes.
continue.
So I'm continuing. Next, we come to secured creditors. Now, there are various aspects pertaining to secured creditors. More important aspects are intersay priorities between secured creditors, and number two, what would be the workman's portion? How would one determine the workman's portion in the security interest? The provisions are there, but are being interpreted in various manner. So there is a need of clarification, which I'll explain with the help of discussion, which I take. Now, we all understand there are two broad sections dealing with secured creditors when it comes to liquidation. Number one is section 52, number two is section 53. So section 52 talks about rights of the secured creditors, as in, unlike in case of CIRP, where there is a clear morat and the secured creditor cannot do anything with the secured asset. But in this case, liquidation, the law helps the secured creditor by giving him an option that you can either stay in the liquidation process, contribute your asset to the liquidation estate, and stand in queue in accordance with section 53. Or else what you can do is to take away that liquidation, that secured asset with yourself, realize it, and then contribute a proportionate part of it to the liquidation estate. How this contribution actually works needs a little bit of explanation. So I have basically two options available with me. I can either realize outside liquidation, or I can actually relinquish the security interest. Now, we have all the forms for filing claims and all. So the law says this regulation 21A was inserted much later after the code was code came into picture. This was a later amendment in the liquidation regulations. So it says, because of the various difficulties in the process, this regulation 21A came. It says that within 30 days of the liquidation commencement date, excuse me, the secured creditor will have to file the proof of claim which is being filed. There, the secured creditor has to say whether he is relinquishing the security interest or he is realizing the security interest. In case he does not state that he wants to realize the security interest, his asset is deemed to be a part of liquidation estate. So basically, there would be a presumption that he has opted for relinquishment of security interest. Number two, in case he says that, no, I don't want to relinquish the security interest, I want to go ahead and realize the security interest all on my own. In that case, the law asks him to provide a proportional contribution towards liquidation cost and workman dues. Now, let me just explain what it means. In terms of section 53, number one priority is that of insolvency resolution process cost and liquidation cost. Number two priority is that of secured creditor who has relinquished security interest, and that priority is being shared pari passu with the workman's dues for the last 24 months. So whatever the secured creditor's dues are, plus whatever the workman dues are for 24 months, these two dues are treated at par under section 53(1) ka B, at par. So in case there is a deficit, I'll subtract proportional amounts from both the claims and then pay them equally, in equal manner rather. So in case, say suppose if the secured creditor relinquishes security interest and there is some realization by the liquidator, he has to distribute the proceeds in an equal manner between secured creditor and workman. So this principle is actually being expanded to realization as well. So irrespective of whether you are relinquishing or whether you are realizing, you have to cede a part of the realizations in favor of the workman. It doesn't matter where you are standing inside the liquidation zone or you are standing outside the liquidation zone. Now, this again comes with a rider of timelines. This contribution have to come within 90 days of liquidation commencement date, and once you have realized the asset, you have to provide the excess of the realizations over your claim to the liquidator within the next 180 days. Now, this 180 days is the deadline. That is, within this 180 days, if you are unable to realize the asset becomes a part of the liquidation estate. Again, within this 90 days, if you are not kind of contributing the proportional amount towards liquidation cost and workman dues, you are again, this law creates a presumption that the asset would become a part of liquidation estate. So the secured creditor basically has to remain active all through. First, he has to say that, yes, I will be realizing. Number two, he has to proportionally contribute to the liquidation estate to the extent of workman dues and costs. Number three, he has to realize the asset within 180 days. In case he fails to do any one of the three, the asset becomes a part of the liquidation estate. So there are various questions which come into mind when we talk about the priority of secured creditors. As I said, the secured creditors share pari passu rights with workmen. First of all, the question is, who do I call, when do I call a creditor as secured creditors? Imagine a scenario where, I say, suppose lent a sum of rupees 100 to you, to say, suppose Barsha, against security of a pen worth rupees 120, suppose. Now, when it comes to, when the insolvency commences, that 120 rupees ka pen has got no value. So can I call myself a secured creditor? That is the question. So the same scenario, if I extrapolate to corporate insolvencies or corporate liquidations, the question would arise, when would I call a creditor a secured creditor? Is he secured to the entire value of his claim, or is he secured only to the extent of his security? So this is a very hypothetical example, a very simplistic example to explain things which I'm wanting to explain or convey to you. So the scenario talks about, say, suppose there is one bank limited. It lent loan of rupees 100 crores to CD Limited. The CD Limited is our debtor, corporate debtor. This bank limited is our financial creditor. So there was a loan of rupees 100 crores. And there was a secured asset. Of course, banks do keep a margin, right? So loan to value ratio, there was a loan to value ratio of, say, and then the secured creditor was worth rupees 125 crores. So on the strength of a secured asset worth rupees 125 crores, I gave a loan of rupees 100 crores to CD Limited. Now the first question is, now say suppose at the time of the company, the CD Limited went into insolvency, and the value of secured creditor as on the liquidation commencement date was rupees 80 crores only. see the value of, see, this is the usual case, right? The value of secured asset in case of liquidation is often very low as compared to the time when the loan was given. So say suppose this asset was worth rupees 125 when the loan was given. It fell down to rupees 80 crores at the time of liquidation commencement, but the actual realization was 70 crores. Now assume this 100 crores remains the same. For a very simple example, the secured creditors claim was rupees 100 and workmen filed their claim for rupees 40 crores. Now the pertinent questions here are, to what extent is bank limited secured? Is it secured to the extent of 100 crores, or is it secured to the extent of 80 crores or 70 crores? Now, can I say that this bank limited will actually drop an asset which would ultimately realize rupees 70 crores in the liquidation estate and can actually claim 100 crores from the entire pool of the CD? Is it possible? Can bank limited claim to be in that position? For example, because the unencumbered assets do not belong to bank limited as such. The bank limited never created a charge on other assets of the CD. Those other assets of the CD are for the unsecured creditors. However, can bank limited put a dent in the unencumbered assets as well? This would be the question. Second question would be, how would one determine the workman's portion in the security? Say suppose this amount realizes rupees 70 crores. How would one determine the workman's portion in it? What will the scenario change if the bank limited realizes the security interest? Now, what happens to deficit of the secured creditors? For example, there are two scenarios. In this case, the loan was rupees 100 crores, but the asset realization was rupees 70 crores, right? So there is a deficit of 30 crores. My value, the secured asset which I actually banked upon, wanting to bank upon, was 125 crores in actual, but when it actually realized, it became 70 crores and my claim is 100 crores. So there is a deficit of 30 crores. That is one deficit. The other deficit is I am sharing this value of security with workmen, because the law creates a pari passu charge in favor of secured creditors and workmen. So this compromise which I am making in favor of workmen, that is also a deficit which I am suffering. What would happen to that kind of deficit? And what would happen to the deficit claim of the workmen? These are some questions which are cribbing questions. We would try to find the answers and would see if there are potential solutions or not. Now, on the first question, can bank limited claim priority for the entire 100 crores? Now, what the jurisprudence say is that a secured creditor's right is only limited to the value of the security and nothing more. So in this case, when we are seeing that the asset is worth only rupees 70 crores, it means that the secured creditor is only worth, his secured claim is only worth rupees 70 crores, and this 30 crores wala claim has become an unsecured claim. So that's what also appears from the ILC report, that the ILC report says that even where it has been relinquished in order to promote overall value maximization. So this particular provision extends to realization as well as relinquishment. In any case, your value is limited to the, so imagine a scenario where this particular bank limited had gone outside the liquidation. He would have recovered only 70 crores, right? He could not have recovered more than 70 crores when he opted out of the liquidation process. So that's, this particular provision is wanting to replicate that scenario only. That's why they're saying this value of secured creditor is actually equal to the value of the security. In case of individual bankruptcy provisions, we see that there is an explicit segregation of the secured creditors provisions under the corporate liquidation part and the insolvency part. So ideally, there is a need to maybe clarify this, that the secured creditors claim is actually limited to the value of the security. Otherwise, different IPs, in our understanding, we have conversed, and they are taking different interpretations. In some cases, they are taking the entire 100 crores as a secured claim. Further, so there is a need for legislative clarity. That's what we are wanting to say. Now, how would one determine workman's portion under 53B? Now, as I said, there is a pari passu charge in favor of workmen and secured creditors, and there are old rulings. For example, Maharashtra State Financial Corporation versus Balarpur Industries, and in case workmen have been compared to be as co-charges of secured creditors, as in whenever sale proceeds are realized, they are to be divided proportionately between the same proportion as their dues. So here in this case, in case the realization is rupees 70 and the secured creditors claim is actually 70, not 100, and the workman claim is rupees 40. So this 70 crores should ideally be divided between secured creditors and workmen in the ratio 70:40. That's what the interpretation comes out to be, looking into case laws and analysis so far. However, there needs to be a legislative clarification on that aspect. Now, what happens to deficit? Again, in case of security deficit, these are the current provisions. In case of realization, in case for example, if this bank limited had gone outside liquidation and had earned 70 crores out of his claim of 100 crores. Just give me a minute. Yeah, sorry. So imagine this bank limited going out of the liquidation process and earning only 70 crores out of this realization. So this 30 crores shortfall, this would come under section 53(1)(e) and would be paid at par with government dues. But what happens to statutory compromise? I am calling statutory compromise for that value which has ceded in favor of workmen. There is no provision for the same. In case of 529A, this kind of compromise was given the status of overriding preferential payments. But in case of IBC, there is no such provision. Whether this is deliberate or not, that is not clear. So maybe again, there might be a clarification needed. Further, in case of relinquishment, what happens in case of that security deficit? As in this case, the bank limited has actually put an asset worth rupees 70 crores in the liquidation estate, but its claim was 100 crores. So this 30 crores, where will it go? It is not clarified in section 53. So again, this either needs to be stated, this needs to be clarified as a whole, all these aspects. Now coming to inter se priorities and rights of secured creditors. There is a famous ruling of ICCI versus Sidco Leathers where it was upheld that the respective bargains which secured creditors undertook with the debtor at the time the debtor was solvent would be respected at the time of insolvency or when the debtor has gone bankrupt. So first of all, let me explain. Security interest can be of broadly two types. One is exclusive, one is shared. Exclusive means only I have created security interest on the asset and no one else has. So in case the debtor defaults, only I will have the right to go and enforce the security interest and fetch that asset and earn my claim, recover my debt out of that asset. In case of a shared security interest, the shared interest can either be senior, junior, or can be pari passu. Pari passu is mostly common where we would see that 8 to 10 banks have created pari passu rights on the assets of the debtor. As in case of a default, all of them can come together, enforce the rights and divide the share proportionately in the ratio of their claims. In case of senior junior security interest, however, there is a senior secured creditor and there is a junior secured creditor, which is subordinated. So imagine a scenario in this case, suppose we carry forward this example. The claim of bank limited was a senior creditor of rupees 100 crore and there was, say, suppose one NBFC limited which was a junior creditor, its claim was say 50 crores. Now the asset ends up realizing only 70 crores. Who would this 70 crores go to in usual circumstances? Given that bank limited was a senior creditor, this 70 crore would first go to bank limited only, not NBFC limited, because NBFC limited holds only residual rights on the asset. Only and only when all the claims, all the debts of bank limited gets satisfied out of that asset, after that only NBFC limited will get a right on that asset. So that is senior junior relationship. Now what happens in case of insolvency? In case of IBC, are these exclusive rights or shared rights protected, or all these boundaries get dissolved and all the secured creditors, bank limited, NBFC limited, whosoever, would be treated at par with each other as if there was no differential right created by any one of them. So this question is very important because that actually determines the recovery or the amount which any secured creditor will get, and that has been a matter of litigation in a number of cases under IBC as well. Earlier, there was a lot of clarity, but after IBC came, since there was no explicit provision protecting those inter se rights, therefore all this confusion came and a trail of litigation followed. So the earlier ruling which I'm talking about is ICICI versus Citco Leathers, but in case of IBC, we see different kinds of rulings. For example, in one case, which is some of these rulings are well before Supreme Court for final adjudication. Still, it might be relevant to note the kind of interpretations which are being taken by the stakeholders. So in this particular case, secured creditors relinquishing the security interest to be treated as one class ranking equally for distribution. So what the INCLAT held was, there has to be no boundary, there has to be no differentiation. All secured creditors can come in and can claim equally from the liquidation estate, irrespective of the value of the security, irrespective of the inter se rights between themselves. However, when we talk about another ruling, INCLAT took a different stand. It said, right to realize security under section 52 of IBC is restricted to a creditor that has an exclusive charge or sole first charge. So here the differentiation, the exclusive right was respected by INCLAT. In this case, it happened. However, TDB versus Anil Goyal it was a different stance which was undertaken. Now, many often we do come across this section 53(2), which says that contractual arrangements between recipients with equal ranking, if disrupting the order of priority, shall be disregarded. So sometimes, a stand is taken that all secured creditors are with equal ranking, and therefore their contractual arrangements, basically the different bargains which they took with debtor, are to be disregarded. However, at the very first instance, it is to be noted that the secured creditors, where they are having an exclusive right over the secured asset, or where they are having shared senior junior rights, their rights cannot be called to be with equal ranking. They are not equally ranking creditors, they are differently ranking creditors. In case of exclusive security interest, their rights are completely exclusive. No one else can come and grab that right. And in case of shared, the senior most creditor enjoys all the rights from the assets first, and then comes the residual creditors. So therefore, section 53(2), neither section 53(1) deal about inter se priorities between unequal creditors. That also needs to be clarified. Again, in case of one ILC report, there have been discussions on this part, but nothing concrete has come into IBC, and for that an amendment might be needed. Again, let's talk about a secured asset where different bankers created pari passu rights. It's very common, right? So you would see a single creditor, single asset, say a large part of the undertaking of the corporate debtor, where different banks have created pari passu rights. Now, when it comes to taking a decision on realization versus relinquishment, can one of those creditors stand and say that, no, I don't want to relinquish the asset, I don't want to realize the asset, I am going out of the liquidation estate and do whatever you want? Can the creditor say that, in spite of the fact that rights are pari passu? So this question again came up before the judiciary, and the judiciary actually held that if the secured creditors having 60% of the value in the secured debt decide to relinquish or realize the security interest, such decisions shall be binding on the other pari passu charge holders. So someone would wonder, where is this 60% and the value is coming from? Because it's nowhere mentioned in IBC, as in if 60% in value of the creditors take the decision to realize the asset, ideally the asset should be left to be realized by secured creditors and should not be taken as a part of liquidation estate. So this is not coming from IBC. This particular ratio is coming from SARFAESI. Just to give you a broad overview, section 13 of SARFAESI deals with enforcement of security interest, and their subsection 9 talks about joint financing. So it says, in case of joint financing by secured creditors, when a particular threshold is 60% in value to enforce the security interest, then only the security interest can be enforced. The similar principle was that the principle was actually borrowed from SARFAESI and applied in case of IBC. However, interestingly, again, I'll talk about the recent discussion paper. The recent discussion paper of IBC talks about consensus of all the creditors. So in case all the creditors should decide not to realize outside the liquidation state, then only it can be treated to be a part of the liquidation state. So again, this has to be seen if it has to be made an unanimous decision or a particular threshold of it that needs to be decided. Now, I talked about realization by secured creditors, where the law has fixed certain timelines. Say 30 days, you need to tell the liquidator whether you are going for relinquishment or realization. There is a 90-day period, 90-day window for providing contributions, 180-day period for realizing the asset. Now, imagine a scenario where the secured creditor decides to realize the security interest. Now he has 180 days to realize the asset. But liquidation period is only 1 year, right? The liquidator has been told to complete the liquidation process within 1 year of liquidation commencement date. Now, in this case, 180 days is anyway getting lapsed because the secured creditor has sought to realize the asset. What if the secured creditor was unable to realize the asset within this 180 days? He will put the asset back into the liquidation state. Now, the liquidator will be left with 1 year minus approximately 180 days of why not make an enabling provision? This will also declog the NCLTs from receiving extension applications time and again. Again, how would the realizable value be estimated? Might be a question of valuation. How would the cost be estimated? No guidance at present. It will again depend upon the best estimate of the liquidation cost in consultation with the liquidator and SCC. Now my colleague Barsha would be discussing on dues payable to workmen and employees during the liquidation period. Before that, in case we have any questions relating to secured creditors, we can discuss that. Or else you can put your questions on the chat box, which we can take up later. Meanwhile, Barsha can proceed.
Right. Shikha, can you please just move to the next slide? So now the concern is about treatment of workmen or employees' benefit, dues, or fund, which is again a very sensitive area, I would say, when it comes to insolvency and bankruptcy code, as to what will be the treatment of the fund created by the company for the welfare of the workmen and employees. Why I'm talking about these? Because IBB has also taken very cautious approach while dealing with this fund, and thus fund, particularly gratuity fund, pension fund, and provision fund, has been excluded from the ambit of liquidation state by virtue of section 36 subsection 4 of the IBC. So coming to workmen's due, what all constitutes the workman due? When it comes to workmen dues, IBC also refers to the provision of Companies Act only. Section 326 of Companies Act has been referred by IBC under section 53 of IBC in the explanation. And when it comes to section 326 of Companies Act, it includes several components of workmen's dues. First, of course, salary and wages dues to the workmen, which along with the compensation as provided under Industrial Dispute Act. Second is any holiday benefit that are given to the workmen or employees. Third, again, is the gratuity, provident fund, pension fund, and any other welfare fund created by the company. So when it comes to treatment of a welfare fund created by the company or created for the workmen, the question arises as to what should be included and what is not included within the ambit of the liquidation state. Let us take some example. First, say suppose there is no gratuity fund or pension fund or provident fund created by the company. What will happen to the if a workman files a claim including those dues with respect to gratuity, provident fund, and pension fund? Again, say suppose there is a fund in the company, however, there's a shortfall in the fund. Then what will happen to that shortfall? Whether that shortfall will be treated in terms of 53 or that will be given a priority. there can be a situation when the fund is created voluntarily. That is to say, there is no requirement coming from any particular statute, unlike gratuity, provident, pension fund. However, the company has created the fund voluntarily. And what will happen to that fund if the workman is claiming the dues with respect to that particular fund? There has been several funds created by the company for the welfare of the employees, senior employees and workmen. So what will happen to those particular funds? Whether that fund is also excluded from the ambit of this regulation, from the ambit of this liquidation state. That is the main concern when it comes to treatment of workmen or employees benefit, dues or funds. So these questions, some of these questions are partially answered in by NCLT in Mosabia or person-partner ruling, wherein it was held by the NCLAT that pension fund, provident fund or gratuity fund dues cannot be recovered as per section 53 and should be given priority. The focus has also been given with respect to the fund. If at all there is a fund created, so that fund will not form part of my liquidation state. The very idea or the very reason behind the same that we believe is that because the component was already deducted from the salary or wages of the workman, hence that salary or wages that were kept aside by virtue of this fund should not be touched by the liquidator and should not be used for making payment of the residual creditors or other creditors. That should be the idea. However, say suppose there is no fund at all, then what will be the treatment? If there is a shortfall, there is a fund, there's a gratuity fund in the company by virtue of the statute was required to create the gratuity fund. There was a gratuity fund created, however, contribution made to the gratuity fund is not sufficient and there is a shortfall in the fund, on the gratuity fund of the company. So whether that shortfall should also be paid in priority or whether that shortfall will be paid in terms of section 53 of the code. That clarity is still required in the code. That is not still there in the code. Even the ruling of Mosabia and person-partner is still pending before the before the Supreme Court for the final decision. Again, there is a recent ruling of Jet Airways where the stance has been taken that even if approved resolution plan, even in case of approved resolution plan, the resolution applicant is required to make payment towards these dues. So resolution plan has been treated just like a going concern sale in liquidation. Say when it comes to resolution plan where the resolution applicant has already proposed a value, has already given a value, and that plan has been approved by committee of creditors and adjudicating authority. Later on, the resolution applicant is asked to pay further money with respect to dues, these dues. The NCLAT in case of Jet Airways has said that yes, the resolution applicant is required to make payment of these dues as well and has to consider these dues apart from the value that he has quoted further. Shikha, can you please just move to next slide? I'll discuss about this rainbow paper
Sure, Barsha, well. But it is interesting to note that different forums are taking different stances. For example, in case of this Sawan Godiwala, the NCLAT has actually said that if there was no fund created, then the liquidation is not under any obligation to provide for the same. So yes, basically the stance itself is not clear.
Exactly, Shikha, exactly these things are happening.
Correct.
Because there are various judgments with variant altogether opposite judgments. Somewhere correct, they are saying you need to consider, so we are saying not to consider. Here we as a liquidator, as a professional, we are getting confused.
Correct, sir. So what generally should be the standards? We should not reverse what has already been done by us. And in fact, let the creditor go to NCLT and see that, you know, these are rulings have come and I need my dues to be paid that way. And then maybe you put your stance that we were not, at that time, these are rulings did not come. So even now, the stance is not clear. So you give me whatever directions, I'll be happy to follow the same. That's what generally the liquidator is left with.
Yes, because it's a very sensitive area, as I said before, and workmen's due includes several components. Components with respect to, of course, these welfare funds, components with respect to the 24 months due prior to the liquidation commencement date, then again dues preceding that period. As we know that in section 53, the priority has been given to the dues of 24 months preceding the liquidation state of workmen dues. Then workmen dues definition provided in the 326 of Companies Act includes these funds as well. On one hand, we are saying that by virtue of section 36, these funds are not included and should be excluded from the ambit of the liquidation state. However, on the other hand, we are saying that 24 months dues, which includes these funds as well, should be paid in terms of section 53. So clarity is required with respect to treatment of this fund, such that the interest of workmen or employees should not get prejudiced by the act. And accordingly, what will happen to the shortfall, what will happen if there is no fund created, what will happen if there is a voluntarily created fund, these the scenario with respect to these aspects should be provided, clarity should be provided with these respects in the code and in the regulation as well. Coming to the next concern, which is about tax dues, which is, I believe, that one of the most important concerns when it comes to insolvency or bankruptcy process. So what will happen to the tax dues, or what will happen to the tax treatment post the liquidation process? Most of the resolution plan, if say suppose acquirer comes and takes the corporate data as a going concern, of course, raise the concern with respect to tax applicability. What will happen to the tax treatment? What will happen to the tax dues, previous tax dues of the company? Am I liable to make payment of those tax dues? Whether at all the priority which is provided under section 238 of the Insolvency and Bankruptcy Code will prevail in case of Income Tax Act as well. Whether I'll be able to get the benefit of set off and carry forward of losses when I am acquiring a loss-making company. Whether I'll get the MAT credit benefit, etc. So these concerns are always there with the acquirer, and we as an insolvency professional are dependent upon the adjudicating authority to answer these questions to the acquirers. So first question is about priority of tax dues vis-a-vis the secured creditor. I believe that we all are aware of the recent Rainbow Papers ruling, wherein it was held that by virtue of a security interest created in favor of a government under GVAT, the state government's due also treated in pari passu with the secure creditors and workmen's due of 24 months. So if we are giving the pari passu treatment to the state government's due, then is it fulfilling the very idea of section 53? Then when it comes to priority dues or payment of making payment towards income tax of the corporate debtor, the concern arises when there is a provision of section 238 which gives the overriding effect over Income Tax Act. Why at all we are not over all the act? Why at all we are not saying that this section, this 238, will not prevail over Income Tax Act as well? In some of the cases, in Monet's Path Limited cases, Supreme Court has held, specifically mentioned this part, that the 238 or the overriding effect of IBC, Insolvency and Bankruptcy Code, will also have overriding effect over the Income Tax Act as well. However, it has been seen that in many cases, what the stance that Income Tax Department has taken is that they have recovered the previous dues against the refund which are pending for the corporate debtor. Now, say suppose the company goes into liquidation in the year 2018. In 2019, company is receiving certain dues, or in 2019, there were certain refund of Income Tax Act which were there. Without remitting that part to the liquidation state or to the account of the corporate debtor, it has been seen that what the company does, what the CRC does is set off that particular refund against the previous dues of the corporate debtor. That is to say, claiming priority. So here, who has given, or how the Income Tax Department is taking this priority over the secure creditors and workmen's due when the hierarchy is already provided? So most of the time CRC is saying that there is an automatic process under section 254 pursuant to which the amount is getting deducted. However, somehow it is not in sync with the provision of IBC, in sync with the provision of section 53 of the Insolvency and Bankruptcy Code. So Supreme Court, of course, as I said, has upheld the precedence of secure creditor over income tax dues as well. So Sudarshan Bhatt ruling is there when Supreme Court has held that IBC has an overriding effect over Custom Act as well. In Andhra Pradesh, High Court, in case of High Court of Andhra Pradesh has held in case of Leo edible oil that Leo edible case, that income tax authorities cannot be equated with the secure creditors and thus cannot claim priority. However, still the clarification with respect to the treatment of income tax dues, or what will happen to the income tax refund, whether at all the income tax department should set off the refund like any other cases when it comes to a treatment given to a company which is undergoing liquidation. So these clarities are required in the code and regulation itself.
So
Shikha,
Barsha, just want to add a few points. It is interesting to note that when we look at section 53, there is already a category under section 53(1)(e) which talks about government dues.
Absolutely.
So the law has consciously created a particular priority for government dues, and in spite of the fact there is all this confusion. Number one. Number two, when we see the BLRC reports and all the discussions, even in the interim report of BLRC, there was a clear and conscious call of giving priority to dues of secured creditors and getting the crown dates below them. So it was a conscious call. Plus, this definition of secured creditor, when we see the definition of secured creditor, it talks about security interest created in pursuance of a transaction. So it talks about consensual act of parties, basically operation of parties, where the parties mutually decide that yes, there has to be a security interest in your favor. But in case of tax laws, it is not a consensual decision. It is a creation of charge by virtue of law, by operation of law. So similar such discussion has been done in this recent IBBI discussion paper, which we were just discussing now. So in that discussion paper, they have also talked about this distinction, and therefore, in fact, sought for a clarificatory amendment in the code, which would override this particular ruling. So hope this particular problem is getting resolved by that kind of a proposal.
Now coming to the treatment of tax dues under IBC. Yes. So tax dues under IBC, as I said, the acquirers are always concerned about the treatment, whether at all they will be liable to make payment with respect to the previous income tax dues of the corporate debtor, what will happen to these losses of the corporate debtor, whether at all they will be able to take benefit of those losses in their books at all or not. Obviously, if someone is acquiring a Bimar entity or entity which is not in a position to revive itself, then obviously someone also the acquirer will also have the intention to get the benefit at least of the losses that were in the books of the corporate debtor. Then it comes to MAT credit, etc. Very often all the insolvency professionals, I believe, have seen the scenario that acquirers are always concerned about the tax treatment as to what will be the tax treatment. Under Income Tax Act, we have seen that when it comes to the tax treatment, the provisions have been amended to include the resolution aspect as to what will happen when the entity is acquired pursuant to a resolution plan. However, no clarity has been given with respect to liquidation, treatment during liquidation, treatment when it comes to the selling of the corporate debtor by way of a going concern sale. In different scenario, it has also been seen that the acquirer or the liquidator has approached the NCLT to get the necessary clarification in this regard, such that the income tax department can give benefit of the set off and carry forward of losses to the entity, to the applicant or the acquirer. It has been seen in case of Gaurav Jain, also in case of Nitin Jain, that NCLT has given the benefit of set off or carry forward of losses. However, those benefits were subject to the consent or subject to the approval of the income tax authorities. That is to say, again, the respective acquirers were required to approach the income tax authorities to have that the benefit of the respective losses in their books. So when it comes to clarity, of course, the clarity is also required in this extent that whether that benefit of these things, of these set off and carry forward of losses and other benefits which are otherwise available in case of resolution process are also available in case of going concern sale under liquidation. Yes, Shikha, can you please just move to next slide, which is about stakeholder consultation committee, their role and the aspects with respect to that requires reform or that requires changes. So when it comes to stakeholder consultation committee liquidation process, this cannot be treated at par with the committee of creditors during CIRP process, because the committee of creditor consists of the financial creditors. Unless there are no financial creditors, there will be operational creditor enrolled. However, committee of creditors comprised of only financial creditors. When it comes to stakeholder consultation committee, this committee includes all the creditors. The representations are there from all the creditors. Even the promoters or shareholders are also required to have a representation in this committee. As per the regulation 31A, which deals about the role and the constitution of stakeholder consultation committee, this particularly provides as to what will be the actual composition of this committee and by what time the liquidator is required to constitute this committee. So timeline is given as of 60 days. First, the liquidator is required to invite the claim. After inviting the claim, the liquidator is required to verify and collate the claim. Liquidator is required to prepare a list of stakeholder. And after preparing that list of stakeholder, the liquidator is also required to constitute this SCC, Stakeholder Consultation Committee, within 60 days of liquidation commencement date. Here, one thing which is interesting to note is that in liquidation, the provision requires the liquidator to have first meeting of the creditors within 7 days of liquidation commencement date. However, the stakeholder consultation committee is required to be constituted within 60 days from the liquidation commencement date. Very clearly, in the first meeting is not happening with the stakeholder consultation committee. The first meeting is happening with the COC. As because the regulation now has extended the role of COC till the formation of this stakeholder consultation committee. The regulation now requires that till the time the stakeholder consultation committee is informed, the COC of CIRP process will continue to be in existence. Now, when it comes to stakeholder consultation committee, the word says consultation. The role is also limited to this word only, which is advisory, unlike the case of resolution process. So when it comes to advisory role, it is limited to advisory to the liquidator. Now, role has also been extended. To what extent? Earlier, the stakeholders committee, the role of SCC was limited to determining earlier the role was limited. However, now the role has been extended with respect to providing the consultation with respect to liquidator's fee, the consultation with respect to appointment of valuers, consultation with respect to treatment of avoidance transaction proceedings, consultation with respect to the manner of sell, inviting bids, etc. So the role of stakeholder consultation committee has been enhanced now. And when it comes to such major decision-making process, we are including all the creditors, representation of all the creditors. We have seen that so far, the liquidation process that has been admitted or that has been continuing, or which has reached the status of completion, hardly there were any payment to the lower priority creditors. The payment has, the realization has not even been substantial to make payment of the first layer itself. So when there is hardly any repayment in a prelim stage itself, the liquidator will be able to at least analyze as to what will be the realization based on the liquidation state formed by. Then after analyzing that, having all the creditors on board or having all the creditors on this stakeholder consultation committee and having their interference in the decision-making process or having any kind of discussion with respect to the realization of the assets or dealing with the avoidance transaction proceeding post completion of the process, of those particular creditors who have nothing to do or nothing to gain from the liquidation process. Why at all I'm saying that nothing to gain? Because as I said, there is very limited process where we have seen that, or there are hardly any cases where we have seen that any payment is given to lower priority creditors. So those who will not get anything are also included in the decision-making process. And again, when it comes to formation, how we are forming, there can be different class of creditors. In secure creditors as well, there can be different class. Secured financial creditors and can also have a different class. Operational creditors can also have a different class. And we are asking each of the class to have one representative. How can we expect the class of creditors to combine and to have a combined decision with respect to having one representative in the board? Is it possible to have or to have one representation from separate class of creditors? So the formation process itself is very questionable as to how the process will happen. Whether at all the respective creditors, can we expect the respective class of operational creditors to have a sync, to have a meeting, and then to decide as to who will represent them in the stakeholder consultation committee? So the formation as to how the stakeholder consultation committee will be formed and who should be a part of the stakeholder consultation committee is required to be further analyzed and required to be further amended and provide clarity in this aspect. Then coming to the scope, as to what is the scope of stakeholder consultation committee, what are the powers that are given to the stakeholder committee? Is it only advisory or is also a decision-making process? So far, it has been seen that the process, the role of stakeholder consultation committee is advisory only. However, the liquidator is also required to now note the reason for not meeting the for a reason of deviation from the views of the stakeholder consultation committee. And not only they record the reason, but also the liquidator is required to report the same to the Insolvency and Bankruptcy Board of India. Along with that, to report the same to the Shikha, I think you are sharing the slide.
Yeah.
Yep. So the liquidator is not only required to record the reason of deviation, the liquidator is also required to provide the same record or the reason to the Insolvency and Bankruptcy Board of India and to the adjudicating authority along with the progress report. So, yes, I think someone is saying something.
Besides Barsha, one interesting thing, the IBBI discussion paper again, which came yesterday, does not seem to be addressing these issues. Rather, it is in favor of kind of including these kind of provisions in the code itself.
And also to enhance the role of committee of creditors in the liquidation process as well.
Correct, correct. So
it will be
only the time will tell whether this will ease out the entire process for the liquidator and the entire liquidation process, or will it make it more complicated as such? So only we'll have to basically rely on time to see the outcome.
Right. Shikha, can you please just move to next slide?
So we are moving to avoidance proceedings. Before that, in case there are any questions,
till now, if anyone has any questions
or some experiences to share, we are open to have a freewheeling discussions here. In case any particular concern you might have come across, any particular experience you have come across and faced issues, and you might have felt that yes, there, the code or the regulations could have actually helped me, but could not. We can actually discuss that part. Okay.
Shikha, you may continue with this avoidance proceeding.
So avoidance proceedings, not much. The provisions are...
Give it a breather time, yeah. Give a breather time. So it's been very fast session and very interesting session. So normally this kind of a speed, no other author is delivering. So it's good that we have a speed now. But at the same time, like, the process, you can do it slow. Okay. Sure. Going back to your earlier discussion, you closed it very fast. Now we'll continue a couple of minutes only. Sure. See, the documents, definitely it's an issue. Because the companies which are coming for the CARP as well as liquidation, we have issue now. And we need to address it. It's collectively all our responsibility as professionals, particularly leave the legal, but the CA, CWS, CS, all three professionals, we need to put our head. Every company we are passing through now, we need to ensure that that year data completely we are zipping and we are holding it, because we have got a right to hold it and we have to hold it. And we need to help at least those companies in which we are representing are really not been in trouble for any future resolution professionals which are coming, which we have to take a oath now, like any other oath that we are taking, that every company that we are doing the auditing, we are the company secretary, we are the cost auditor. Whoever is that responsibility, we need to hold it. Otherwise, it's not going to mean anything. That's the first thing. Because at least going forward, we can correct it. Always the course correction is more important. For this only, we need to all put our head and suggest to the body also that, we need to do this. Secondly, we are not having data for sure. So what do we do? That, it is not that, don't try to find a reason. When everybody asks questions, we don't have a data, zero data, negative data that we have got whenever we are going to certain companies which are coming to the CRP. Because the companies which are coming to CRP, the admissions itself is delayed by 2 years. Not less than a year or two, which it takes for the CAFP process to get admitted. The current situation where I have given concern of companies which are chronic and which are not even considered for even the hearing. Most of the time it is posted for hearing 200, 300 numbers in Chennai NCLT level, only one judge is available. So we need to address the problem of NCLT. That's all of us have to do, address the NCLT issue. Coming to now the problem of the data, if it is not there, what do we do? Yes, see, we are not going to pay, be very honest, these companies, we are not going to pay to the operational creditors. There are not going to be money left. If really we need to pay, then both of them will have to bring them to the table. If you need money, get us the books and we need to get it from both of them. And most of the time, at least the creditor side, who is operational creditor, we have got a set of rules, and if they have got all the data, we can take it. Other than the published information, we are not getting any information, any support, even if it is available from the corporate data. So we need to put a clear-cut decision and as to what to do. And unless NCLT is sorted out, all of us, we can keep on talking. All the NCLTs are having trouble. 92s are never a problem, a matter of importance. Even the case admission itself is not important. And even everything, even resolution plan submitted and 1 year is pending in one of the cases in where we are representing. So there's no timeline or turnaround time for them. At least somebody reviews that as our bodies, we will be very happy. So
sir, I would just
92 is not going to be. I'll conclude it. So 92 is not going to be possible. So we have to go for NCLT for direction, even for these cases where we do not have. I'm talking about CARP. Because you are taking liquidation now. Liquidation debts come. So you are, as a liquidator, you and I are the authority now. We cannot shift it to the NCLT for normal matters. So we have to take the decision. We need to corroborate all the evidences that we have got. We have to accept it or reject it. If you are unable to take the decision, we need to refer it to the NCLT. We do not have authority to refuse any of the claims which are made with you with the plain reasons. That does not substantive reason. Even with that, you need to take, if there is no books of account, we need to refer it and mention it even in the to the adjudicating authority that we do not have, and we need to take the guidance. And beyond that point, discussing in this forum is a waste of time. And thank you. And I hope anybody else has got objection, they can talk.
So sir, your NCLT part is actually right. The time lost in all those proceedings is, of course, none of us would have faced a smooth way out from those proceedings. Every one of us is in the similar in one or similar issues, right? But the problem is more about infrastructure, which I feel, because even the judges are burdened. We cannot even blame them. We are seeing they are doing multiple shifts.
No, see, we have to blame the system, because only one judge available in the thing, and he's part of the time is dedicating the time for volumes of cases. It's injustice. It's not justice. It's injustice to the system that we are addressing. It's wrong. We cannot keep continuing. We have to take it up to the matter as a body, governing body, even IPAs should take it up with the the ministry concerned, and they need to do the recruitment. We offer the resources, all the senior members. We should offer us the technical members. We should offer ourselves who is the legal team available. They should offer themselves for the judge position who is available, and let us build up the case and take it to them. They cannot continue this situation, which is going to kill this entire the spirit of this act. Can I expect Barsha and Shikha to take it forward after this session?
Sure, yes, sir. In case we had the breathing space, we can proceed further. Okay.
It was rightly mentioned by you that currently, yes, the reforms is required with respect to the NCLT's approach while dealing with the cases. And I believe that the amendments which are being introduced and are also being proposed are mostly with respect to this manner itself, to resolve or to provide some concrete decision with respect with this regard. I believe, Shikha, we can continue further. You may start with this avoidance proceeding matter. And
so avoidance proceedings, not much, just some sort of clarification, we see that, the law avoidance procedures are there under section 43, undervalued transactions are there under section 45. The look back period in case of unrelated parties is 1 year. In case of related parties, we need to look back for a period of 2 years, because the chances are more that the transactions would have been conducted with related parties during this period of 2 years from the insolvency commencement date. Now, there was an ILC recommendation that this threshold date is to be changed to the initiation of CIP process, as in when the application was actually filed. Plus, there is no look back for transactions defrauding creditors. Now, when we talk about section 49 and section 66, so this section 49 talks about transactions defrauding creditors, and this section 66 talks about fraudulent trading. So when we see sections 43, 45, etc., we see that the law has prescribed look back period for those transactions, but not for fraudulent transactions, which itself means that these transactions are not subjected to any such look back period. So even if these transactions were done prior to 2 years, say 4 years, 5 years, whatever, ideally these should be covered. There has been some discussion around it, because we have heard IPs talking about that the NCLTs might have taken a different meaning. They refuse to go beyond the period of 2 years, even in case of section 49 covered transactions. However, that shouldn't be the case, and therefore there might be a need to clarify this stance. Also, in case of undervalued transaction, the law defines it to include a gift, or where the value received was lower than the value given. However, there can be various schemes where there can be various methods or arrangements whereby these undervalued transactions can take place. For example, carving out a subsidiary and shifting out the assets into the subsidiary, or similar things. So these all again can be looked into. Now, when we talk about treatment of these continuation of these avoidance proceedings post dissolution, there have been discussions around it. Earlier, there were amendments. There had been recent amendments in Regulation 44A, where the liquidator is required to consult the SEC, basis which he kind of files the application. When he files the application for dissolution or closure of proceedings, he also writes as in which manner these avoidance proceedings would be taken. So although this is there in the regulations, again, writing this only in the regulations may not be working. There might be certain amendments needed on the line of section 26. Now, what does section 26 say? The section says the filing of an avoidance application under so and so clause by the resolution professional shall not affect the proceedings of the CIRP. So this particular provision can be extended to liquidation process to basically substantiate and complement this particular regulation, whereby the confusion in the minds of judiciary can be taken off. Now, coming to the most important part, which we were discussing recently, just minutes ago, adjudicating authority and legal proceedings. Now, when we understand, right, that there are infrastructural issues and there are certain limitations, and plugging those limitations, addressing those limitations can require substantive changes and thus might take time, right? However, there are certain possible areas where we can kind of minimize the time required to be devoted by NCLTs. There are certain matters which are purely adjudicative in nature, or purely non-adjudicative in nature, basically very routine matters, where very housekeeping type of matters, which may be either taken up by IPAs or IBBI, or maybe completely taken off the books. Basically, there should not be no need before the liquidator to go to NCLTs, or for that sake, any other authority. For example, condonation of delay. This may be provided in the court that, say, suppose during 30 days, if you receive the claims, well and fine, there can be a grace period of, say, further 30 days. In case you don't receive the claim shouldn't be accepted. These kind of things. For example, at this time, we also need to go to NCLTs after we are done with the voluntary liquidation. Voluntary liquidation is a very simple process, as I said, and there should be no requirement of going to NCLTs. There have been proposals around the same. Let's see what happens on that front. Again, in case there is modification of time, submission of progress reports, these days we need to file an affidavit and a progress report together before NCLT. That again may not have been required, right? For extension of time, the liquidation process has to be completed within a period of 1 year. Now, this timeline is not compulsorily compulsory, right? This is some kind of a directive guideline, and it is obvious that, timelines may require extension given the complexity of the process. This thing may not be required to be gone to NCLT, may be taken care of by IBBI as well, or IPAs as well. Or maybe maybe the liquidator can simply give a justification in the progress report, and in case there are any objections, the registry or say the IBBI can come across and ask for clarifications. Similarly, there can be deadlines for the operational creditors to submit, for any creditors to submit a claim. Plus, NCLTs are often clogged with frivolous applications. We have been victims to it, and in fact, most of the IPS would have been victims to it. And they are able to file and proceed with filing multiple such frivolous applications because more often than not, there is no cost on them. So it's ideal to have some sort of penal measure where frivolous applications, where on the face of it, it is very much evident that the applicant has come with, dirty hands, and therefore the NCLT should have explicit power to penalize this frivolous applications and applicants. This again finds a reference in the IBBI discussion paper where they have given similar kind of proposal. Besides, we have faced this issue, we are facing this issue, and other IPs would also be. For example, we see various labor matters being taken care of by different labor authorities where they are asking the liquidator to pay off the dues. They are not aware of Section 53 provisions. They are not aware of the priorities under code. They are not aware of IBC. In spite of the representations being made, there is less of sensitization on their part where, they can align themselves with the code. So this is not happening. Therefore, there is a need to have express clarifications on both the sides. From the side of stakeholders of IBC, from the side of stakeholders of those very forums. Plus, in case of, there is another provision which I should talk about here is moratorium during liquidation. So this is dealt with under Section 33/5. This particular provision says, subject to Section 52, when a liquidation order has been passed, no suit or other legal proceedings shall be instituted by or against the corporate debtor. So the word here is shall be instituted by. That is, there should be no beginning of any suit or legal proceeding. It does not talk about constitution, continuation. For this very reason, what happens is there are an array of litigation against the corporate debtor which continues beyond the time, even after the liquidation proceeds, and that continues even when the time comes to dissolve the entity. So that kind of hampers the liquidation process. So ideally, this was also proposed in the notes to clauses of the IBC bill in 2015. So this should ideally be changed to include institution by, or no other suit or other legal proceeding shall be instituted or continued. Then ideally it would be aligned with the intent of the provision. This again is also a proposal in the IBBI discussion paper. Barsha can take the discussion forward with schemes of arrangement, going concern sales, and voluntary liquidation.
Right. So when it comes to scheme of arrangement, we have treated the provision. We know the provision under Companies Act, Section 230, review Section 232, that provides a detailed process when it comes to a scheme of arrangement. Scheme of arrangement now has also been included and made part of the liquidation process. The very idea of including this scheme of arrangement during liquidation process is to give one more chance of revival to the entity, which is already in the deathbed, one can say. So we can say that when the committee of creditors has decided to move the company into liquidation, they have already framed one opinion in their mind. What we are doing is, when we have moved the company into liquidation, we are giving one chance of revival again by way of a going concern sale. That let's see if going concern sale is possible in the liquidation process, then a chance should be given to the going concern sale. However, what is the very reason or very idea of including scheme of arrangement is not clear still, because there was no reason of including the same initially in the BLRC report. The idea came later on and included not in the code but in the liquidation process regulations to include this scheme of arrangement part as well during the liquidation process. Now, what will be the treatment? To what extent the provision of Section 230 has to be followed? who are required to vote, and what will be the voting procedure. There, we all know that when it comes to Companies Act, there is a detailed rule, compromise and arrangement rules, which provides the detailed manner in which a scheme of arrangement has to be taken care of. However, when it comes to scheme of arrangement during liquidation process, no such regulation, no such guidelines is provided. Merely a timeline of 90 days is given. We have seen so far there are hardly cases, some 4 or 5 cases are there with respect to scheme of arrangement. None has still achieved the very reason of including the scheme of arrangement during liquidation process. And what will be the scheme? What will be the process? Who will include the scheme? What consent will be required? Because we know that when it's come to scheme of arrangement, Companies Act requires you to take consent of the shareholders of at least 90% when it comes to seeking dispensation, or majority in head representing 3/4 in value of present and voting. When it comes simultaneously, when it comes to creditors, there are consent required from the different class of creditors. So when there is a liquidation process, there are different set of creditors, from financial creditor to the last priority creditor. How will we take consent? How will, if say suppose there is requirement of conducting meeting, how the meeting will be conducted? In what manner the consent will be required? What will be the role of promoter? There is no clarity in this regard in the process till now. So this, with all due respect to the judiciary and to the Insolvency and Bankruptcy Board of India, I believe that including scheme of arrangement or giving one more chance of revival to a company, apart from the resolution process and going concern process, is nothing but is time consuming, and can be said that is one of the reasons for which the insolvency and bankruptcy process is not getting completed within the given timeline. So on one hand, we are struggling with the timeline. We are trying to string the timeline with respect to the respective compliances that are provided in the liquidation regulation and code. On the other hand, we are giving chance after chance to the company which is already in that bed to get revived. So if at all there is any requirement of revival through a scheme, the detailed process to be followed by the respective professional should be provided in the code, which is currently not there. And the timeline, which is of 90 days, is next to impossible to achieve. And there was a proposal to shrink that timeline further to 30 days with respect to completion of the scheme of arrangement process during liquidation, which has not yet been implemented, but may get implemented in the coming days. So obviously, it is not possible as per the current scenario to approach or to complete the scheme of arrangement process when it comes to following the provision of section 230 during the liquidation process. There is a requirement of detailed deliberation in this regard, detailed regulation in this regard, to provide as to what mode, what processes are required to be followed when it comes to using 230 in liquidation process, and what process are not required to be followed and can be excluded from the ambit of the process of scheme when it comes to scheme of arrangement during the liquidation process.
So,
coming to
Barsha, just to add here, as you said, there might be gaps where I'm superimposing section 230 during liquidation. So this fact was also acknowledged by the Insolvency Law Committee in its 2020's report, where it explicitly said that section 230 of the Companies Act is not aligned with the liquidation process of the code, and these two processes are quite incompatible. Although it said that yes, there can be an appropriate process where the liquidator can effect a compromise or settlement with specific creditors. So they were not talking about compromise or settlement under section 230, but specific set of compromises which the law has not explored as yet. Plus, when we look at figures, the data, you said 90 days is the current provision, and there is a proposal to reduce it to 30 days. But again, due to various involvement of NCLT at various stages, and for other reasons as well, this timeline goes above 400 days, right? So that again is a question as to what is the viability of these kind of schemes of arrangement.
Even in some cases, Supreme Court has also refused to comment on the merit of these schemes. Correct. We have seen the case of Jindal in this matter, wherein Supreme Court has refused to comment on the merit of scheme. Now, coming to the next aspect, which is about going concern sell. While I have briefly discussed this part while dealing with the tax concerns, as most of the concerns are with respect to the tax only. Now, as per the amendments, the liquidator is required to try the going concern sale in the first auction only and cannot try the going concern sale for the further auctions. So if the first auction fails, then liquidator has to try the remaining option, and this option of going concern sale is not available. When it comes to going concern sale, there are two options: either to sell the concern, the debtor, the corporate entity itself as a going concern, or business corporate debtor as a going concern. Still part of taking by a going concern sale, then the second process, which is selling the business of the corporate debtor by way of a going concern sale, has to be followed. So when it comes to going concern sale, obviously most of the time acquirers have this concern as to what will be the treatment or tax benefit, what will be the treatment of the losses that were there in the books of accounts of the corporate debtor. And we have seen that in most of the going concern sale, the acquirer or the liquidator has filed the cases before the NCLT for seeking clarification with respect to these things, that whether the license, the contract which were there in the name of the corporate debtor will continue. The corporate debtor will get the entity which is being sold by way of a going concern sale will be able to continue the business with all the amenities, with all the benefit that were earlier available to the corporate debtor. The tax exemption will be there or not. So these concerns are always raised by the acquirer before the adjudicating authority when it comes to going concern sale. Section 54 accordingly has been amended to include the part that when it comes to going concern sale, when the body and the soul both has been sold, then there is nothing remain, hence nothing to dissolve. However, when it comes to slump sale, wherein you are only selling the body and soul remains, in that case, the soul is required to be dissolved, cremated. So accordingly, in that case, when there is a slump sale or other modes of sale apart from the going concern sale, then the application for dissolution is required. However, in the case of going concern sale of the concern of the corporate debtor, the application for completion is required to be filed with the adjudicating authority. Clarity, of course, is required with respect to the treatment of the statutory liabilities, that none of these statutory liabilities will continue with the entity if the entity is going concern. If sold by way of a going concern, that the tax benefit will be available with the corporate debtor when the corporate debtor has been sold by way of a going concern, and necessary amendments in this regard are also required in the Income Tax Act. As I said, the Income Tax Act currently only refers to the resolution plan, but not covers the aspect of going concern sale. So this aspect, this treatment is also required to be provided in the code, in the act, in the regulations, with respect providing the clarification when it comes to going concern sale. Coming to the next slide, which is about voluntary liquidation process. We all know that voluntary liquidation is about solvent company when the company has sufficient assets to meet its liability and is able to pay its dues. In that case, the company opt for this voluntary liquidation process. So obviously the process has been provided in detailed in the voluntary liquidation regulation that starts with taking the declaration of solvency from the directors, from majority of directors of the company. Amendment has been made with respect to including the aspect of providing provision for the storage of documents in the declaration of solvency as well. However, when it comes to attachment to be made with the declaration of solvency, the provision requires you to attach the financials of the company of the previous 2 years. Practically, it has been seen that as on the liquidation commencement date, if the accounts of the company is not updated and not audited, in that case, the liquidator is required to get into the same and get the accounts audited such that the receipts and payments account can be taken effect to accordingly. So this, I think in my view that the clarification should be required, or this part should be amended to include the accounts of the company, audited accounts of the company as on the liquidation commencement date, so as to provide the actual picture of the corporate debtor as on the liquidation commencement date. Now coming to the other part, the process, there are no such detailed cumbersome process when it comes to voluntary liquidation. It is quite easier comparatively to the normal liquidation process, as the process requires, of course, the realization of assets and then distribution. But distribution is, while of course the process of section 53 also continues when it comes to voluntary liquidation process. However, one can say that voluntary liquidation is about solvent liquidation. So as to say, you can give an example of a dinner table that food is enough for everybody. So there is no question of any priority as to who will come first and who will have whom to serve first will come when it comes to voluntary liquidation process, unlike the normal liquidation process. So the manner of distribution is also comparatively simpler when it comes to voluntary liquidation process. The clarity is required as to what will happen to the subsidiary or to the parent company when it comes to, say, suppose the parent company is getting voluntarily liquidated. What will be the fate of the subsidiary companies? Or say, suppose the parent company is getting voluntarily liquidated. So what will happen to the fate of the subsidiary company in that case? So these clarifications are still required in the code. What will happen to the corporate guarantee that are provided by the corporate person during the voluntary liquidation? This clarification should also be there. Then, given the voluntary liquidation process is generally obtained by a solvent company only, liquidator should also be given right to adjudicating the claim post the last date of receiving the claim, as because the voluntary liquidation process also refers to submission of claim till the last date, till the 30th day's timeline from the date of invitation of claim. So when it comes to voluntary liquidation process, the role of NCLT generally comes to the end, at the end. However, say suppose if someone has not submitted the claim within the period of 30 days, then provision of 42 is there, under which the delay is required to be condoned by the bench. And as my colleague Shikha has just said that it is very much required to declog the NCLT from these frivolous application or from these kinds of application which does not require intervention of the NCLT as such. So these rights can be given to the liquidator to adjudicating the claim when it comes to a solvent liquidation, to the liquidator only. So to adjudicate the claim that are submitted post the period of 30 days, because we are saying that the liquidator has sufficient assets to meet liabilities or make payment towards the towards all the creditors, including the statutory liabilities of the corporate debtor.
Barsha, besides, although yes, these are some important aspects. Another important aspect in voluntary liquidation is contingent claim, although that might not need some sort of regulatory intervention, but that is an interesting question, right? Yes. What if, so in case of voluntary liquidation, we also take consent of creditors, and once the creditors agree to voluntary liquidation, the liquidation actually starts with effect from the date of special resolution. Now, what if there are contingent claims? Do I invite those creditors also to vote whether they are eligible to vote? And what do I do with those claims while giving the declaration of solvency? Will those contingent claims actually matter? That maybe if you are able to throw some light on it.
Well, Shikha, currently the provision requires you to take consent of 3/4 of the total creditors of the company. When it comes to creditors of the company, of course, when it comes to solvency, and we know that ultimately the company will go into dissolution aspect, all the claims should be considered. And so far, you are taking the consent of 3/4 of the creditors. That will suffice to initiate the process. When it comes to dealing with the contingency, so far the contingent claim can be sustained or can be ascertained by the liquidator. The payment can be made to that regard after, of course, making payment to the other creditors in terms of the priority or in terms of the availability, in terms of the realization made, because payment, of course, you are making to all. You are not deviating payment of anyone. Because you have realized the assets, you have made payment of all the creditors, you are distributing the surplus money to the contributories, and at the end you are just reporting to the NCLT to dissolve this company because nothing is there in the company. So even the contingent claim, even after making payment of all the creditors, if at all there is a contingent claim, I believe that should also be taken into consideration.
So probably you are talking from the perspective of that declaration of solvency, where it says that the company will be able to pay off its debts. Absolutely. And how can we disregard contingent debts, right? And interestingly, there are provisions where the liquidator can actually look for, pausing the entire voluntary liquidation process if he feels at any point of time that the realizations will not be sufficient to cover the debts and the declaration of solvency can actually be rendered negative, right?
Absolutely,
So
absolutely.
there are
This forms the
provisions.
very charter document. You can say that the very first document that requires to initiate a process. So that is why the process begins with this declaration of solvency itself. The first concern or first responsibility has been given to the directors of the company to determine whether at all the company is solvent or not. And if at all they are of the view that company is solvent enough to make payment of all the dues of the company and is not going into voluntary liquidation to defraud any creditors, then only they will enter into this declaration of solvency, because this declaration of solvency can have its own liabilities or owns liability on the directors of the company as to on what basis they have substantiated that the company was solvent. Again, as you know that during the liquidation process as well, the right has been given to the liquidator to report to the NCLT if at all at any moment liquidator thinks that the company is not capable to make payment of the creditors or is not solvent. If at a later date, because of the contingent claim or because of some statutory dues which were not disclosed at the initial stage, if at the later stage liquidator comes to the notice that if it comes to the notice of the liquidator that there are certain dues to which liquidators, the corporate debtors asset is not sufficient, in that case, liquidator has also been given right to approach to NCLT and to go opt for the normal liquidation process rather than going for this voluntary liquidation process.
So basically, there would be a switch from the voluntary liquidation to compulsory
normal liquidation. Absolutely, yes.
Courtesy, so I think I'll please confirm the other years. Thank you.
Yes, I think.
Sorry.
Yes, Mr. Mishra, I think you are saying something.
Sorry, I'm sorry.
I have a question.
Yes, sir.
A technical one. In voluntary liquidation, by the amendment, it is said the liquidator shall endeavor to complete the liquidation process within 90 days and 270 days. Right? In voluntary liquidation, generally what we do is we clear out all the debts and we go for the liquidation. So in one of my cases, there are no creditors. There is a refund pending from the income tax department, and there is a income generated by the 9 months time for which I have to file the return. So in this case, technically, I will not be able to complete in 90 days. So in that case, do I need to go to the promoters to extend the time, or do I need to approach the NCLT? What is the clarity on that?
Sir, if you see the regulation, as you have correctly mentioned, that when there is no creditor in the company, the regulation has shrunk the timeline for the liquidator to endeavor to complete the process within 90 days. However, it is not binding to complete the process within 90 days. I have to try my level best to complete the process within 90 days. Right. If at all, for any reason, the process is not getting completed within the 90 days, in that case, I am required to write the reason, to note the reason of the same. And of course, when it comes to voluntary liquidation, entire exercises depend upon the contributories. So we are reporting to the contributors. We'll take consent of the contributors that this is the reason because of which I'm not able to conclude the process within the given period of 90 days. And if the contributory is consented, then you can continue with the process, because role of NCLT is at the end when you are done with the entire process. So right. In between, you'll not see that there is any intervention of the NCLT when it comes to voluntary liquidation process. So entire consultation will be there with the contributory, as you have seen also in case of the cases when there are creditors. That also says that if you are not able to conclude the process within the given timeline, earlier that was 1 year, now it has been reduced to 270 days. So the earlier provision also says that if you are not able to conclude the process within the period of 1 year, in that case, you are required to go to the contributories. You are required to convene a meeting of contributories within 15 days from conclusion of 1 year. And after taking consent of the contributories in that regard, after placing the annual status report before them, so as to give your entire chitta as to what exactly you have done so far and why the process is not getting completed. After taking these facts into the consideration, the contributory will allow you to continue with the process, and that particular record that contributories has allowed you to continue with the process beyond a period of 1 year has to be also included in your final report along that you will file along with the dissolution application.
So in short, 90 days period before that, I need to call a meeting of the promoters.
Yes, ideally that should be done when you think that, of course, there can be certain cases when it comes to income tax refund, which for which you are waiting or you're not, you will analyze that initially within the period of 90 days, you'll not be able to receive that that fund in the company's account. So you are left with two choices, either to ask the ultimate beneficiary to forgo that amount. Say suppose the amount is very small, 5,000 rupees or 10,000 rupees, you can ask them to forgo that amount. And if they are not ready to forgo that amount, in that case, you are required to continue with the process. For continuing with the process or to forgo the amount, either of the cases can be chosen, and the ultimate beneficiary is the contributory. So you are required to take consent of the contributories only, because there are no creditors involved in it.
Yeah. One more question.
Yes.
Sorry. As I said, in one of my cases, for 9 months, there has been an income generated. So in that case, is it practical? I pay the taxes. I do the audit of that particular period prior to the liquidation date. Whatever taxes are there, I pay them, and I don't wait for the filing of the return. And I straight away go for dissolution. Because
so
then
yes, please complete, sir.
So then there will be nothing left as such to wait for. Okay.
Sir,
is it a
I
right
believe
practice?
that you are referring to income generation during the liquidation process.
No.
Then,
prior to the income, see what has happened is 31st March 2022, 1 year is completed, return is filed, 143 order is received. 1/4/22 till my liquidation commencement date, 9 months period prior to the liquidation commencement date, a certain income is generated, for which I need to do the audit. I will make out what tax is payable. I will pay it as an advance tax. I will pay some more amount, say 5,000-10,000 more. And then should I wait for, because the returns will be notified in May, June. Right.
So ideally, what happened is the income generation during liquidation process that you are referring to, I believe, might be either some rental incomes may be there, or the interest income. Say suppose there is an amount which is which has been deposited in the liquidation account, and there is an interest income. So of course the tax will be levied on that particular interest income. The idea is not to escape the liability towards the income tax. So if at all there is an income, you are required to make provision with that respect. You are required to make payment, advance payment towards that income tax before approaching the NCLT with respect to the closing of the process. While there is a circular of IBBI that now has excluded the specific consent or specific NOC from the income tax department when it comes to voluntary liquidation process. However, still it is advisable to go to the NCLT and to income tax department and approach them with respect to their dues, if any. Because even though the circular of IBBI that refers to the voluntary liquidation process has given you the exclusion to go for the income tax department for the NOC, however, there is no exclusion in the income tax provision. If you have seen the income tax provision section 176 read with section 178, that specifically requires you to approach the income tax department at the initial stage itself. So initially you are reporting to the income tax department that if at all there is any due, let me know within the 3 months time. So you have to be, the timeline of 3 months is given to the income tax department to report their dues. And if you're not receiving any report or any claim of income tax department within that 3 months, then you are free to distribute the assets. So in either case, you are required to wait for that 3 months. You are approaching the income tax department and taking their consent. So it is always advisable that the process should be in terms of or in lines of the income tax provision read with the IBC code. The idea should not be to deviate, or the idea should not be to disregard any liability of the corporate debtor, because again you are saying that your corporate debtor is solvent enough to make payment. So when it is solvent, then there is no question of not paying the dues of income tax department.
No, you are taking me wrongly. What I'm saying is that before the voluntary liquidation process started, there was a period for which the return is to be filed, right? And that will be, because it is 22-23 financial year. So for that, notification of income tax return will be in May, June 23. I will be paying advance tax. There will be no exception of tax. I will be auditing those accounts for that period. Whatever tax is payable, I will be paying it as an advance tax. So there will be no escape of tax. What I'm asking is, okay, for this period, should I wait for the notification of return to be filed for 22-23 financial year, or should I go ahead with the dissolution?
Sir, I would say that given the timeline is already 90 days when it comes to closure of the process, and you are saying that within 90 days, say suppose the return is already not there in the forum, how will you file the form?
Absolutely.
Right. So again, I would say that a clarification is required in this regard as well as to how will be the return filing will be done by the respective professional when the form is not there. When the form itself has not been there in the portal, how will the liquidators expected to file the return? So all you can do as per your situation, you can of course approach the income tax department initially with respect to the dues, but filing is something on which clarity or respective insertions is required in the Income Tax Act to provide the clarity in this respect.
Rather, Barsha, what I would say is my task as a liquidator is to realize and dissolve the company, right? These all, say suppose paying tax of course is my obligation. If I don't pay the tax, I am liable under the income tax law. But yes, filing the income tax return is something which is administrative in nature. It's not substantive. I have paid the dues. It is something which is administrative and technical. So ideally speaking, I should not be required to wait for filing the return. I've paid the taxes, right? I'm aware.
I believe that there can be a situation wherein, say, suppose you have made the provision or you have made the payment towards the advance tax as per your computation. The computation of the income tax department can be different with that of your computation. There can be more income tax liability. There can be a less income tax liability.
I understand.
In case there is a less income tax liability, then you will get refund. In case there is more liability, in that case, you are required to make further payment. So this is one aspect, one area which of course requires clarification.
It is very tricky.
Yeah, correct. But liquidators should anyway not be required to wait for again, you know, that period till the time the return is filed and till the time the entire assessment is done. I'm just waiting for the filing returns and getting that assessment order while all my tasks has been
done. So in that case, we should move ahead with the dissolution process.
Ideally, yes.
And as and when the notified return comes, we can file it if required.
Because maybe Barsha, what we can do is to state in the application itself that in case there is any assessment of the income or during this period, any refund or deficit may be dealt with in accordance with, maybe we can write there that the contributory may take care of that. Maybe.
See, if I may,
yes, ma'am.
If I may add to that, in one of our cases, we were required to give an indemnity from the, in fact, I being a liquidator in one of the voluntary liquidations took an indemnity from the contributories. If there is any deficit, they will take care of it. It is not a liquidation as you pointed out post CIRP, or it is a voluntary liquidation. So being a solvent entity and based upon the decision of the contributories, they need to give an indemnity if there is any such case to take care of such situations. And this indemnity should be attached to the application by the liquidator for dissolution order.
Very correctly mentioned by you, ma'am, because ultimate beneficiary of the surplus fund is the contributories. So if I know that whatever is the surplus will go to the contributories, I can either ask the contributories to be responsible for the contingent claim or for such kind of liabilities which may incur after filing the dissolution application. Because once the liquidator files the dissolution application, the liquidator is also required to close the liquidation account. And when I have already closed that account, where the refund will go? So I have to make provision in this regard. I have to insert particular clause and will have to take this indemnification affidavits from the contributors in this regard, that whatever liabilities will arise later on, that will be compensated, that will be paid by the contributors, because they are the ultimate beneficiaries of the same.
Ma'am, further to this, we have already completed our voluntary winding up. We have filed with the NCLT. But now income tax has, after almost 6 months, done a faceless assessment, and they have come out with a requirement of dues. So now how should we proceed? Whether we need to intimate to NCLT or we should ignore as per the November 21 circular that we are not supposed to take an NOC from them, because we have waited for them for almost 3 months, but no demand had come in.
Ma'am, I believe that the very idea of removing this part of taking particular NOC from the income tax department was to remove that cumbersome process, or to remove or to manage the process within the given timeline. Correct. And not to deviate, or not to, not paying the income tax liabilities. So say suppose there were income tax liability assessment are of course happening later on, later date.
No,
so
ma'am, this everything was assessed, everything was clear. And now they have come out again with a faceless assessment and they have reopened that matter. So
madam, let them go through NCLT. NCLT also asks us to send notice to the departments. Okay. If they have any claims, they need to report to the NCLT.
Okay. Besides, ideally, these must be redirected to the contributories, I think. The erstwhile directors and contributories.
What I was planning is I'll just take a letter from the contributories that if any demand is that they will pay, because we have already closed the accounts. Anyhow, I don't have any money to pay. And with that data, I can tell NCLT to dissolve the company.
Ma'am, in any case, you are a liquidator, you are a fiduciary, you are not aware of what happened in that time. So ultimate data of that particular period, if at all there will be any assessment, that has to be provided by the contributor or the ex-management of the company only.
Correct.
You are not aware as to on what basis they had filed the return. Correct. So of course, one may approach to the NCLT in this regard that I have completed the process, the very process for which I was appointed. My appointment was with respect to realizing the assets, making payment of the liabilities. I have invited claim from everyone, and I have accordingly distributed the realized proceeds. So, and again, I have made provision with respect to the contingent claim as well. So if, and in any case, I am not aware of what will happen or on what basis they have coming up with these assessment now at a later stage. So accordingly, NCLT may provide necessary clarification and necessary orders in this regard to, deal with these aspects by the contributories only.
Okay.
So, ma'am, we are also facing the similar cases. There are, of course, so many matters of ours as well, which are pending before the adjudicating authority. Some are, of course, pending for dissolution from some last 3-4 years of voluntary liquidation process, I would say. And some matters in which after filing the dissolution application for 4 years, we are receiving the reports or the assessment proceedings order from the income tax department. So we are also taking the same approach, ma'am, and that is why we are saying that the clarification in this regard is required in the regulation.
That's true.
Absolutely.
Yeah. Thank you so much.
So, Barsha, there are a few other practical areas or concerns which are in practical experience are faced by IPs, and maybe you can discuss it in case.
So other areas when it comes to closing the liquidation process are, of course, first is regarding dissolution, early dissolution of the corporate debtor. Presently, the process is allowed under Regulation 14 of Liquidation Regulation. So, but the realizable property of the contributories of the corporate debtor, if not insufficient, then what will happen in that case? How this entire process will go? That clarity is required in that regard. When it comes to stock exchanges compliances, SEBI has come up with the several amendments in the SEBI regulations with respect to compliance to be followed by company which is undergoing liquidation. However, say suppose the acquisition is happening to a company which is listed company. So whether the provision of takeover regulation, SAST regulation will be applicable on the acquirer, or to what extent that will be applicable, whether the open offer process will be applicable on the acquirer or the not. So clarification in detail is required in that regard as well. One of the very important aspect is with respect to liquidation cost. As I believe that you all are aware that now the liquidator are also imposed with one more responsibility, which is to comply with the other applicable laws on the corporate debtor, which is Regulation 27B of the insolvency resolution process, which says that what will not form part of the liquidation cost. It says that any kind of penalty or fine imposed on the corporate debtor for non-compliances of any of the provisions applicable on the corporate debtor, that penalty, that fine will not form part of the liquidation cost, and that has to be borne by the professional out of his pocket. So this is something which has, I would say, enhanced the role of the liquidator and has made the process more cumbersome on the liquidator's part, because now liquidator is not only required to see the applicable provisions of IBC. The liquidator is also required to see that there is no violation of any of the law which are applicable on the corporate debtor.
So Barsha, just pitching in here regarding this aspect. This circular was already there in 2018, and anyway the law requires the resolution professional or the liquidator to kind of comply with all applicable laws, and everything. The difference which this provision is creating is, while the circular carved out something saying that, you know, the liquidator will not be held responsible if the non-compliance is not due to negligence, basically. The liquidator will be held responsible only if it is due to the negligence of the liquidator. However, this particular carve out is not available in this regulations, which again, these kind of provisions are borrowed from the circular, but not with explicit clarity. So that's what might need, again, alignment with the provisions of the circular. Some other few aspects as Barsha discussed, for example, compliances under SAST. Now imagine a liquidation estate which has say assets called shares of some listed companies amounting to more than 25%. Now, as and when a buyer comes in to buy those shares, the SAST will of course kick in, right? Because the concerned investment is an investment in listed securities. Now there is no exemption, so he has to go through the entire takeover process. While there is an exemption for resolution plans, but not in this case. So there is disparity. This might also need to be bridged. Now, talk about stamp duty on sale of assets. When we are selling off immovable properties, stamp duties are calculated on circle rates, right? Fair values. But in case of liquidation, the sale is not happening at fair values, right? The sale is happening at distressed values. Now, when the buyer goes to the registrar for registration of the sale, the registrar charges same stamp duty as in case of fair value. So that again becomes a demotivation for the buyer. So these are the kind of various kinds of compliances or various kinds of provisions which can be aligned to serve the needs of IBC, basically for value maximization, because these all sorts of compliances are deterrents for the buyer. The buyer would think twice before getting into these sort of compliances, are thinking about the stamp duty implications also. So ideally, these laws may be tweaked, may be aligned to provide relaxations in case of IBC acquisitions, going concern sales or sale of assets, etc., and maybe made more favorable for the times to come. Again, the session is open. We heard some experiences aligned with our experiences. We would want to know more in case you would like to share your experience with us.
Ma'am, can you throw a bit light in voluntary liquidation? If we have to do a distribution in kind. Say in one of my cases, there were shares of private limited company, and I distributed it in kind, that is pro rata. I transferred it to the shareholders. But the taxation part, how it will be treated, because in books it has an X value, while the fair value of that particular company, if we go for valuation, maybe X plus something. But I cannot transfer it at X plus 1 because I have to clear the books. So I had transferred it. जो books पे था वो मैंने transfer किया amount पे. And as far as I went for the income tax provision, it says that the deemed capital gains may arise when they sell it. The holders. I just wanted some insight on this when we do a distribution in kind.
So when it comes to distribution in kind, of course, the provision is there to make distribution in kind, and the time to make distribution is now being shrinked to 30 days, within which you are required to make distribution to the realized proceeds among the contributors of the company. When it comes to the taxation aspect, there can be two things, of course. First can be deemed dividend. The other can be of capital gain aspect. So if at all there is any accumulated profit in the company, so to the extent the distribution is made towards the accumulated profit, that will be treated as a deemed and the remaining part, if they suppose the sale is happening more than the market value of the company, then the difference between the two should be treated as capital gain aspect. Well, the income tax part, I believe that this is to the extent as far as our knowledge is about in-kind distribution during the liquidation process. Shikha would like to add something in this.
Yes, so maybe we are talking about the price, the consideration at which shares would be transferred. To my mind and to the best of my knowledge, although we might have to look at the provisions in particular, not handy with me, but ideally this should take place at fair value, because otherwise there would be implications, there might be implications under section 56, etc. also. So not sure, but ideally, yes, the consideration I cannot pass in case I am, basically the exchange, the transfer in specie distribution should also take place at fair value. And therefore the capital gains should ideally arise at the level of CD also, Barsha, right?
Yes, absolutely.
Correct.
Ma'am, I have a question here. Basically, it is in regard to liquidation under section 33 onwards. In case of CDs who claims or who said that his records are destroyed by fire and he has no account books, etc., and even his computer systems and data is not available, and once you go for liquidation and after dissolution, you need to file the updated balance sheets, etc., to get the company. Can you throw some light in this scenario? What will be the outcome? Because I'm facing the same situation here in one of my assignments.
So I believe you're talking about the normal liquidation process and
Yes.
not the voluntary liquidation process.
Yes, I'm talking about normal liquidation process.
So in case of normal liquidation, of course, it has been seen that in many cases, the insolvency professional fails to get the cooperation from the corporate debtor and thus fails to get the status of the books and records of the corporate debtor. Then it becomes, of course, very difficult for the insolvency professional to adjudicate the claims, if at all any claim is coming to the insolvency professional.
I'm interrupting you. It is not issue relating to claims.
I do understand, sir. It is about the completion of the process that you are saying, right?
No, I'm one step ahead. I received the claims. Claims to an extent are verified because the claimants are basically the secured financial creditors only in this particular case, or the government claims are there which are already verified. The issue is in regard to, because last 2-3 years balance sheet or accounts were not prepared. So once you go for dissolution, you have to file all those things. Otherwise, MCA will not allow you to get your company dissolved.
So so Barsha, sorry interrupting. What I feel is, in case there is a genuine case of fire or where the records have been completely lost, what could be done is that liquidator can arrange to put on professionals and a pro forma financial statements can be prepared, giving due disclaimers that these financial statements are only pro forma financial statements and prepared by the liquidator, prepared by the professionals appointed by the liquidator, given the circumstances. But the case seems very rare where there wouldn't be any electronic records. Ideally, this might be a case of non-cooperation. Ideally, I think so.
They have the balance sheet of, say, till financial year 18-19. After
Okay.
that, they have not filed it, and neither they claim the data is not available with them.
Okay.
That is one. As far as this provisional financial documents are concerned, we got it prepared from say chartered accountants, etc. But the MCA is not accepting the same. They said, no, we need the correct financial statements. There is no concept of provisional financial statements in that regard.
This you are filing at what stage?
See, the liquidation is over. Now the stage of dissolution is there. So for getting the company to be dissolved, you need to file all these updated documents. Then only the company can be dissolved.
Basically, to update the status of the company on the MCA.
Yes, you are right.
Sir, I think this is more of a procedural problem and needs to be settled.
I know that. But as far as I scratched my hand and everything, in IBC, in Companies Act, in rules.
No, so there are no specific provisions relating to
Yes,
these things.
yes.
In fact,
I believe
IBC,
there were cases that we also dealt in the past wherein there was dissolution of the corporate debtor, and what we did is we have simply filed the order of the NCLT with the MCA, and we have
Correct.
not filed any accounts of the company because of course there was a significant gap in the accounts of the company from the day we initiated as an insolvency.
ideally that should work. That should
Yes.
work. But Sanjeev
So
sir is
we
saying
al-
maybe
we
registrar is asking.
We already filed the liquidation order passed by IBBI, sorry, NCLT, and we have done all the procedural requirements.
Because
Still-
sir, the requirement of filing the updated accounts is not coming from any regulation or code per se, if you see.
But what they say ki, to get the final order of dissolution, you need to file all this.
But if
Otherwise-
NCLT is passing the order of dissolution, I'm not sure why they want the.
Because
In fact, there was an MCA circular, Barsha, if you recall, which talked about, signing documents by
on
in
behalf
case of
the
CIRP.
company,
Yes, exactly. And then filing with MCA, and that should suffice. I think there was a circular.
So there is
Yes,
a
you are
circular.
correct.
You are right. There is a circular.
Correct.
And all those statements definitely those were filed with the MCA under my signatures only. But what they are saying is ki, there is no concept of these provisional or financial statements. Either you have to say these are the financial statements, file it, or otherwise there will be an issue in accepting those.
So I believe you are referring to MCA only, MCA's
Yeah.
issues only, right?
Yes, yes. Because otherwise you won't get a.
So sir, I would like to add upon here that MCA do not have power to dissolve the company. The power is with the NCLT. If NCLT has dissolved the company.
No, ma'am.
But he's talking about updating the status on MCA.
Yes. You need to update the status on MCA website.
So, sir, better go to NCLT and
yes, better to have a proper order in this regard from the NCLT
and give a direction on the
MCA is
MCA
taking
to
such
accept this
stance.
as the final.
Maybe I have not explored that. That can be explored.
Because you will be left with no other. You're left with no other option, right?
Yes,
either it can be an informal discussion with the backend registrar, or it can be an NCR.
No, I had a discussion with the registrar and even to the extent of RD also.
Okay.
But they raise their hands.
I believe, Shikha, that we can take an example of this case and accordingly can henceforth any of the dissolution application that the company is making may also add this prayer that after dissolution direction may be given to the MCA to stop the name of the company in this regard. Right?
That will be a good option. That will be a good option.
So if that will be, because in that case, the particular aspect of striking of the name of the company will be captured in the order itself. And accordingly, I believe there will be no issue from the MCA's end to giving effect to this.
Yeah, thank you.
If I may, if we are on the same page, if it is about, changing the status of the company at MCA data, is it that what we are discussing here?
Yes. I think Sanjeev ji was talking about the same.
So there, as you rightly pointed out, there is a circular. So once the order is received and is filed with ROC, generally what we do is we write an email to IBBI, the Voluntary Liquidation Division, for giving, because there used to be some CFF forms or CRF form, change requisition form earlier, which was never available on the MCA website. So now what we have been doing is we have been writing to IBBI to give instructions or write to MCA for change in status, and it has been done smoothly recently. You see, in the last 6 months, we have done that for 2-3 companies. Previously, yes, initially if we talk about era 2 years back, it used to take 6 months, 7 months. In one of the cases, it has taken 9 months as well. But for change of status only, I'm saying. But recently, the process is we write to IBBI after we have received the order, after it is being filed with ROC. We write to IBBI that the adequate or necessary compliance has been done. And IBBI writes to ROC and the status is changed.
I think Sanjeev ji can follow the same.
This statement that you are, ma'am,
ROC
this statement that you are talking about.
These instructions. Sorry, ROC also had sent me a mail accordingly that I have to approach IBBI and they will instruct ROC and then ROC will change the status to, they cannot do on their own anymore.
Right, and it has been done smoothly.
And this is about taking the status of in liquidation in the MCA portal. However, taking the status of striking off or struck off in the MCA portal, there will be an issue faced by the insolvency profession, and accordingly it is advised, of course, to include this prayer in the dissolution application itself.
That can be done, but we have to intimate IBPI, and IBPI will instruct ROC to change the status to dissolve.
Yes, that's what, and it has been done.
That option may also be opted. Yes, of course.
Yeah, that is what ROC is advising. They have sent me a mail accordingly.
Their problem is basically, in case of Sanjeev, the problem is unique because they're also attaching provisional financial statements, and the ROC is again negating that fact that this is not acceptable. So that the case becomes a little unique in that sense.
Even there are several cases wherein companies are going voluntary liquidation or liquidation process. However, status of the company is still showing as active or inactive in the MCA portal. So these are the issues that, of course, insolvency professionals are facing. Yes. Any other concerns, any other questions, or any other experience that anyone wants to share?
So there is a small query that I had. So initially for the voluntary liquidation intimations that we used to give to ROC, we used to file that in GNL2 form, followed by MGT 14. But now this V3 era, that is still in the process of implementation. So now nowadays, how do we intimate ROC? I sent a physical intimation yesterday. I mean, I wrote an email followed by a physical intimation. Is there any clarity for LLPs and for companies for intimation to ROC for voluntary commencement of voluntary liquidation?
Ma'am, till the time this V3 portal is getting active, will not be able to comment on the same. But yes, of course, the provisions required you to intimate the regulatory authorities, including registrar of companies. And even physically, you have given intimation to the registrar of companies. So far this portal is getting active. No one will be able to file any form. And I believe that the timeline has also been excluded from the ultimate timeline of intimating the registrar of companies with respect to commencement of the process.
So, yes, there has been a circular basically.
Ma'am, INC 28 form is to be filed.
Yeah.
No, I'm saying for commencement.
Yeah, for
I'm
commencement
saying for
also
commencement.
After dissolution also, INC 28 form is to be filed.
Physically to ROC.
So INC 28 is regarding the order of the adjudicating authorities.
Yeah. And if you file INC 28, then once it gets approved, the status gets changed.
No, sir, it is not about the status of the company. It is about the intimating the ROC with respect to commencement of the process itself. So when it comes to informing the ROC that the process has commenced, you are required to initially take the approval of shareholders by way of a special resolution, and accordingly you are required to file form MGT 14. So ma'am is saying that MGT 14 form is not there currently on the portal.
Ma'am, you have to file a physical MGT 14 along with the resolutions and GNL2 along with all the necessary documents. Once V3 portal is ready, you will have to again file that with the attachment.
Because that timeline will be excluded. The filing of that,
there won't be any
will be excluded from the ultimate timeline given to you to intimate the registrar of companies.
So that is for companies, and for LLPs, there used to be some form 1, which is no more available. So was the intimation being done through GNL2 only for LLPs as well? Though I have already done it physically, since there is no form, but just for the sake of clarity.
So till the time MCA is coming up with the new portal with all the arrangements therein, will not be able to comment on the form part as to what particular form they will accept. So of course, we all have to wait for the forms of the MCA or introduced by the MCA in this regard now.
Okay, thanks. Yep.
Any other concerns? So I think we can close the session today, Shikha.
Right, Barsha. And in case they have any queries, of course, they can mail to us. Please feel free to contact us in case you have any queries. And Nitinji, we may close. And it was, I should acknowledge that it was an interactive session where we also learned a lot. about the experiences. And
Nitinji, over to you.
Thank
Sure,
you so
ma'am.
much.
Thank you. So thanks to both the speakers. Thanks to all the participants sparing your time for this discussion, giving your very valuable inputs. And we also look forward to have similar sessions in the future. Thank you very much.
Thank you.
thank you, Nitinji.
Thank you, everyone.